November programme signed. This is the Northern Ireland.
Open session. The red light is on. One apology from Philip.
We have.
Yep.
He has delegated his vote to Mr. McHugh.
So, can I maybe skip that one? Yep. Declaration of interest. Any members any interest to declare? Nope. Chairperson's business. During the consideration stage of the Parental Bereavement Leave and Pay Bill yesterday, the Department for the Economy Minister indicated that the Department of Finance had advised in terms of the Bill's amendment that the potential repercussive costs of making the provision throughout the UK in line with the parity principle risks losing over £100 million per year from the executive budget. However, if we look at this guide, and I know we haven't got it as well, it does talk quite clearly about the issue about when we're doing it, and I'll just sort of bring it up, that the question of super parity. And obviously there's an issue to do with if the Northern Ireland Executive decide when it comes to AME issues as well to look for something that is outside and is more generous. That is deemed to be super parity. And that cost, for as far as Northern Ireland is concerned, comes from the DEL envelope. But nowhere does it state it will be from the rest of the United Kingdom. So we wouldn't be paying the cost of the United Kingdom. For those of us who are old enough, I remember being in the Economy Committee when I was told something similar about RHI, about one of the reasons why we had to make a declaration on, or to make a decision on RHI, I think way back in the dim and distant past. And again, that proved to be a piece from that was in the same department, or the department DETI as it was at the time, who were making it clear that there would be additional costs and it would be a UK-wide issue, which of course was proven not to be the case. In view of this, I think I would just like to write to the Minister and the Department and ask them to get clarity on that. Because as far as I'm concerned, as far as I'm aware, and indeed from the Independent Fiscal Council, is super parity, if we decide to go for a super parity issue, only applies to Northern Ireland. And I would like to see the detail of where the Treasury State will be paying for the rest of the United Kingdom for that, because I know it's not the case in Wales and it's not the case in Scotland, and it hasn't been the case previously in Northern Ireland for welfare payments. So if we were content to do that, to seek clarity in this matter, agreed. Draft minutes of the Finance Committee meeting on the 24th of November at page 7. Are we agreed that this is an accurate record of proceedings? Agreed. And there are no matters arising. Excellent. Thank you very much indeed. And if we move on to the next item, which is oral evidence from Mr. Paul Tweed. Can we bring Paul in?
Yep, they're just going to get him.
Paul.
Good afternoon.
Come on, make yourself comfy.
Cheers, thanks.
Team, this is, as most of you probably already know, this is Mr. Paul Tweed, a well-known media lawyer. He's coming here to give oral evidence in respect to the Defamation Bill. The Clerk's briefing notice at page 18. Paul's response is at page 25. Clause by clause bill for the table is at page 30. Assembly research paper on defamation is at page 68. The Defamation Bill and explanatory and financial memorandum is introduced at page 145. Paul, you're very welcome, and I hope you don't mind me calling you Paul, but you're very welcome to the Committee for Finance. As you're aware, we're taking evidence on the Defamation Bill, and we are the sponsoring committee for the bill that is going through, and it's under the auspices, obviously, of Mike Nesbitt, but we're taking evidence to do that, to be able to support that, and sort of the processes we're going through at the moment. I'm going to ask you to, and just keep it to about sort of 10 minutes, because we couldn't probably afford your ghost fees for much longer than
the clock's off today, Mr. Chairman.
I'd just like you to talk about your submission on the committee stage of the Defamation Bill, and if you do over that, and then could you just explain to us what you like or dislike about the bill and how you might like to see it amended, please. But over to you, please, Paul. Thanks.
Okay, no, thank you, Mr. Chairman. Members of the committee, very grateful to you to give me the time to talk here, and as I say, certainly the clock is not running, so don't worry about that. If I may just, Mr. Chairman, just give a bit of background and context just to my comments before I make them. Just at the outset, to set out my position, as you will have seen just from my written response, I think this bill is A, a waste of time, but B, it will be bad not only for the general public of Northern Ireland, but also for the mainstream media, and they don't seem to understand this. I perhaps have the advantage, for what it's worth, of practising in the 3 jurisdictions, Northern Ireland, Republic of Ireland and England and Wales. And I was also on the Ministry of Justice panel that debated the 2013 bill before it was made into law. I was opposed to the bill strongly at that stage, and perhaps my views were prescient in that I believed it did absolutely nothing to solve the number one problem, and that's the problem of the social media and search engine giants. Most of my work nowadays is not against the traditional media, but it's against Google, Facebook and all those companies that they control and operate. My position is that we have horrendous difficulty trying to get defamatory material taken down, but defamatory material also falls into the category and the realm of misinformation and disinformation, which is basically the cancer of today. I have tried with my colleagues, we try to take on the media for clients who can afford to do it. Bear in mind, so far as Northern Ireland is concerned, there is no legal aid available for defamation cases. Unlike in the Republic of Ireland and England and Wales, we are not, under Law Society regulations, we're not allowed to do a no fool, no fee. We're not allowed to do a CFA, a contingency fee arrangement. There is a dispute, although I believe we are entitled to accept third-party funding, but when I was sitting on the defamation panel set up at the High Court in Belfast under the former Mr Justice Gillen, we had a bit of a debate and nobody actually agreed whether TPF was in fact legal in Northern Ireland, but I take the view it is, but having said that, it has never been used. A fundamental problem, on one hand, for us lawyers, and nobody will have an iota of sympathy for me even saying this, but the legal costs for defamation cases in Northern Ireland are extremely low. They don't match, they don't come anywhere near what we would be paid in London or Dublin. In fact, I could not run a media practice if it was based on the work I do in Northern Ireland. It just does not pay. That's a good thing for the public, and it's a good thing for the mainstream media. In contrast to that, and I've just come out of a fairly major interlocutory battle in London, the costs to determine whether a matter is either a meaning of a matter or whether a matter is serious harm or whatever are eye-watering. Eye-watering. They make the damages seem absolutely small in comparison. So if this legislation, this bill is introduced and passed into legislation, we will have a situation where I have no doubt English lawyers and English QCs and barristers will come in to practice here. And that in turn will push up the legal fees, the general legal fees, plus the fact that all these issues will have to be debated before you come to substantive hearing. And there is a big advantage in having time before the costs start to escalate dramatically.
Just in your opinion then, if this legislation went through, we've heard previously that there isn't any form of sort of libel tourism, for want of better terminology, or defamation tourism. Is your contention would be if this went through, this would then change that calculus?
Mr Chairman, I don't know if it would change it in terms of libel tourism. I mean, nobody can give me an example of libel tourism. Not one example. Yeah. And yet if you read the media, read the papers, there was this big fear that libel tourism, they were going to come in here like Triffids, that Northern Ireland was going to be like libel capital of Europe. Now that hasn't happened. And there were hysterical reports, particularly in the Belfast Telegraph. Didn't happen. And they're now concentrating the latest scenario, and if I may just to follow on in your point, Mr Chairman, if I may, you know, one of the main protagonists here for the bill to be introduced into law, is the journalist Sam McBride. Now, I have a lot of respect for Sam as an investigative journalism. I think, he's got courage, and I wouldn't like to be on the receiving end for one of his investigations, but he's got to be respected for that. But he did a report in the Belfast Telegraph, which is still up there, saying journalists want to bring the public the truth, but they will need help to do it. And it's vital that Northern Ireland's defamation law is changed. But underneath that headline, he's got a photograph of Dr. Christian Jessen leaving the court in Belfast, seeking justice. Dr. Christian Jessen arrives at Belfast High Court during the libel case taken by former First Minister Arlene Foster. Christian Jessen was not coming to Belfast to seek justice. My client was trying to seek justice. He was laughing at her. He's showing absolute disrespect. Fine for me, I'm just a lawyer, but he was showing disrespect to the legal system in Northern Ireland. But the Belfast Telegraph still cannot help but try to turn this round. Now, this would not get over the serious harm threshold. It wouldn't get over the defamation law as it stands today. But this is the sort of subtle stuff that we have to deal with on a daily basis. Now, it's no problem if you want to make it harder for me and my colleagues to deal with it. That's fine, so long as everyone understands the consequences, both in terms of increased legal fees, in terms of letting the social media giants off with it, letting them get away, because Section 5 of the bill here is giving them absolute credibility to be able to say, we're just a platform, we're not a publisher. And if I may cite Ian Hislop of the Private Eye, many years ago we were battling with them in the 1980s, but he made reference, he said, if this is justice, then I'm a banana, and I may be misquoting him. I'm afraid if Facebook and Google and all those companies that they control along with our lives, if they're just a platform, then I'm afraid I'm a banana as well. And so we've got to think, Northern Ireland, we should not be treated as some sort of poodle that we have to follow through. Scotland are standing firm and have their own changes they want to make. Northern Ireland should be the same. We do not need any change in our defamation law. We do not have libel tourists. If there is a problem with scientific research or academic research being interfered in any way, I'm all for preventing that. I mean, we can put a block on that or whatever. But I would like one example just so that I can at least give my opinion on it. The example given by Dr. Wilmhurst relates to England and Wales. It does not relate to Northern Ireland. And as I say, the way things stand at the moment, there is no chance of us becoming a libel capital of anywhere. That's just not happening, and it hasn't happened.
Okay, thanks.
So if I may then just turn to the second reason that I think this is a bad idea, and I've referred to it already in relation to the social media giants. This Section 5 is more or less verbatim, at least part of it. The full section hasn't been included here, and I'm assuming there might be a reason for it, but I haven't just quite understood. But anyway, the Section 5 is just, it's taken from the English 2013 Act. Now, I said at the time, what is the point of this? In a libel, if somebody is called a terrorist by a business rival or a political opponent, that goes round the world in 7 seconds. I remember back in 2006, whenever we were first consulted by a Hollywood personality of the day, and it was National Enquirer. National Enquirer had never apologised, and we got stuck in them. We didn't have to issue legal proceedings, but we used whatever, shall we say, assets were at our disposal, and they agreed to do an apology. And I thought to myself, they just started their European edition, which was a big mistake. They didn't realise they were subjecting themselves to European libel, privacy and data protection laws. But I just thought, right, okay, what use is a little, what we all call the Daily Mail postage stamp apology? That's going to mean nothing. So I tried it, and I got to put it back down the internet, and I watched it going from here, across Europe, across Asia, Australia, into LA. And we got the vindication for her at that stage. Now, today, if something is posted on Facebook or a tweet is put out, what are we going to do? We're going to go to Section 5 and we'll work out what we've got to do here to try and, just not offend social media, but, ask them to identify who's behind it. And then it's not them, we go after the person that posted it. Now, this is all very well in theory, and there are lots of theories, and I'll come back to those in a moment, if I may. But if it's your daughter or your son who's been hammered here, and they come into me like, we need to stop this. Am I going to take a few days, a few weeks to see if I can persuade them, if I can even get a reply from these people? Mm-hmm. But you're telling them you're just a platform. You're not responsible. You're not a publisher. You're not like if a letter is published in the newsletter or the Irish News, well, that newspaper will be responsible because they have to check what's in the letter, and they do. And they do it responsibly normally. They don't have to do that. They've even, Facebook have decided, look, it's not enough to be my own judge. We want a jury as well. So they've set up, they've picked 20 people, they picked 20 people to form an oversight board, their jury. So they're now judge and jury. I mean, I cite the George Orwell's 1984 and Big Brother. 1984. I mean, that was quite interesting. But if you look back, I would guarantee when we come to 2024, 40 years later, and we think of Big Brother is likely to be the social media and search engine giants because they'll have all our data, they'll have all the power, they'll be more powerful than government. They're not certainly worried about a £10 million fine, I can tell you that. Nothing. So at the very least, this institution, I mean, Northern Ireland, we've produced a number of US presidents, a number of people around the world that have made a difference. We have got to show here, look, we are going to think about this. And it may be after listening to me, and you've got a lot of other people you will be listening to, I'm sure, you may decide, look, Paul Tweed, look, typical lawyer, sure, it doesn't matter. But all I'm asking is you think about what I'm saying before you put this, and do not be bullied by the media. I've continually bullied, whether it's from BBC, Northern Ireland, newsletter, everyone will try and bully each way, and that is what this is in many ways, because they've got the platform. And I remember, I mean, in fairness to Sam McBride, in that article where I referred to earlier, I mean, I wrote to him, not a legal letter, asked him nicely if he wouldn't mind changing it. It hasn't been changed yet, but we did pay a big compliment to the late Liam Clark, the former political editor of the Belfast Telegraph and former editor of the Northern Edition of the Sunday Times. Liam Clark was a great friend of mine. He was a great journalist, and he was also a client of mine. And he was a very successful litigant because people attacked him continuously. But I remember one day, I was incandescent with rage. There was an article, I can't even remember what it was now, so it shows what, I maybe got dementia creeping in here now. But I was raging, and I rang Liam up, and I went absolutely nuts. I said, look, this is outrageous. There's no balance. This is totally unbalanced, this article. This is totally unfair. And Liam, as he was wont to do, just laughed, totally pulled the rug from underneath me, and he said, Paul, media don't need to be balanced. We don't need to be balanced. We just need to publish the facts and the truth, and we can put it whatever way we want. And that's absolutely right. But so the public reading this, they don't hear my point of view. They don't even hear your point of view. That's what it is. So I'm more than happy, Mr. Chairman, if you want me to go through the bill point by point, or if you want me to pick out the points in it, like serious harm threshold, or if you feel I've done enough to sort of give you my views on it.
Just because we're collating the sort of the information for sort of the bill and sort of the clauses west, but particularly if you want to talk about sort of clause 1, particularly the serious harm one, and potentially because you mentioned the Gillen previous and sort of the Gillen review, maybe on clause 11, just for those particular points.
Sure. So serious harm, again, I think this is more or less taken directly from the 2013 Act in England and Wales. What is serious harm? I don't know. It's put to me many times, and I'm getting a different answer every time. The courts look at each case on its own merits. So somebody could call me an idiot. That's not serious harm. You can't really libel a lawyer, can you? But they might say that you, Mr. Chairman, have been very circumspect with the truth. Now, it depends, one, how broadly that's disseminated. Two, whether the recipient took it seriously or not. And three, your particular circumstances at any given time. Because sometimes we all have a period in our lives, it may be that we've just applied for a new job, and a comment that is defamatory, but maybe would not normally be over a serious harm threshold, but that moment in time it is. So it's debate. Lawyer's dream. We will have great crack over this, and I might come back into Northern Ireland. I mean, I've only got about 5% of my work here at the moment, but I might come back in and have to spend more time here, and we'll all get paid more. And as I say, we'll be taking on our colleagues from across the water. So I personally do not understand. The courts are they put us through the mill. Any case I have, and what I would urge, and if I may, if you haven't already done so, and I brought a copy along with me, I would urge the committee to just read the judgment of Mr. Justice McAlinden in the Arlene Foster case. It's quite a lengthy document, but it gives you an idea of the type of scenario that libel lawyers are up against. It covers the whole ambit. And you've got to work out, this serious harm? Would this pass the serious harm threshold? Now, we'll have a good old debate about it, because in fairness to the judge, it was probably one of the most carefully prepared and copious, and I should say excellent judgments I've come across in recent times. He left nothing to doubt, primarily because initially the defendant was a personal litigant, and then he brought lawyers in. But I think it is very, very important.
If you you're so kind, if you could give us a copy of that, and we'll have that placed in the record. Thank you very much indeed.
But basically, it gives a good feel of what we're about. But serious harm, in my opinion, is it's not something that is just you can write a note and say this is serious harm. It depends on individual cases, and that means debate. And bear in mind what I said earlier about the general public. It's all right for a wealthy person can take and have a pop, and if he loses, or she loses, whatever. But the ordinary person just does not have the financial means to pay us lawyers to go through all this stuff. And that's the unfortunate fact of life. Now, if you want to introduce legal aid for defamation cases, great, we'll do that. But my view is it is not. It should not be brought into law here.
Okay, thanks. And clause 11.
So, yes, the jury trial.
Yeah.
Now, perhaps Mr. Alistair would probably be the same. We're probably unusual in that I was practising at a time when juries were in for personal injury cases. So that was back in the early 80s, before they were abolished. And I would have to say, and I was on the defence side then, I was acting for insurance companies in personal injury type cases, employment liability cases. And I would have to say the juries, in my opinion, never got it wrong. 7 people drawn at random from the citizens of Northern Ireland. And I'm of the same view. I mean, we fought a very lengthy libel action for the late Barney Eastwood against Barry McGuigan and Channel 5 Video way back in the early 90s. Again, 7-person jury, got it absolutely right. I would say that anyway, of course. But the juries, I think, do get it right. Don't ask me to explain why, but just the mind, and I think it's very important to bear in mind in Northern Ireland that there are very strong religious and political undertones here that perhaps are not present in the rest of the UK or in Ireland or whatever. So I would veer towards keeping the juries, but I don't feel, I wouldn't be jumping up and down. The 125,000 that was awarded to Arlene Foster, it was the exact same figure I had on a piece of paper before the decision was given. So that was a judge alone. That was not a jury. Yeah. And so, I mean, I don't think it's necessary to get rid of juries, but if that makes people feel happier, so be it. But I think we should be prepared to trust the ordinary man and woman on the street. They're not stupid.
Thank you. Jim?
Just to carry on that theme slightly, obviously the basis of defamation is the damage to reputation in the eyes of your peers. Is there not therefore an affinity between that and having a jury to make that decision?
I think that's an excellent point, and Mr. Alice, you obviously haven't lost your touch there. In fact, if you bring in this legislation with the fees going up, you might be coming back to the bar full time. It might be worth your while. But no, that's an excellent point, and that's totally right.
And just the other point on serious harm, the corollary of bringing in serious harm is to effectively say that that which isn't serious may be irritating and many other things, but you can tell the small lie and get away with it.
Yes, again, that's again a fair point. And just back to the point that I'd made, it depends very much on the person's, the victim's circumstances at the time. You know, just sometimes a small lie can have a massive effect, just because it so happens that there's maybe he's maybe buying, selling his company, or applying for a job, or applying, you know, in the middle of an election. You know, the election 3 weeks before an election, sometimes something said can be enough to tip the balance. So it really does depend on circumstances, and that's all got to be debated and paid for. And you know, we can spend days in court, you know, going through all this, and that to me is needless.
I think one of the key issues in judging this legislation relates to social media, and you've spent some time on that. How would you compare how our present law can deal with social media as to how this bill would deal with social media?
I think our present law is totally ineffective as well. Totally ineffective. The law is not geared to deal with social media. When the original legislation was drafted, obviously there was no online threat or problem. And the difficulty at this time is that while the social media are able to rely on the ECOM directive, which is their main thrust at the moment. I'm not sure how that's going to pan out post-Brexit, but that's it. Or Section 230 of the legislation in the United States that gives them protection. Both those pieces of legislation were brought into force long before we had Facebook, Twitter, or whatever, breathing down our necks. So, to answer your question, Mr. Alistair, I think we need tough laws, and I would like to see tough laws against social media. But the only one problem we've got here is all the social media companies have taken advantage of tax tourism to set up their EMEA headquarters in Dublin. So Ireland has to be the pivotal centre point for taking action against Google, Facebook and Twitter, Microsoft, etc. and Amazon, if we can pin them down there. And that's another big issue, because what they're doing, they're saying to us is, if I go in against them for an Egyptian company, they come back and say, oh, they've signed up to the United States, Facebook Inc. or Google Inc. or whatever. So this is a battle ahead. Amazon are the same, trying to pin them down. It is horrendously difficult at the moment, horrendously difficult.
Yeah, so this legislation would of course, give them protection as a mere platform. How do you prove publication generally? Or is it sufficient to prove mere publication by a media giant, such a social media giant?
Again, an excellent question, and there are two answers to that depending on the jurisdiction you're in. In the Republic of Ireland, the Jameel principle does not apply, so you just have to show basically one person. So we've got to get somebody to say, look, or confirm that they had downloaded, accessed or posted. Here we've got to show a meaningful degree of publication, and again, we would have to, the client would have to produce witnesses to say, look, I saw that, and I downloaded it,
What's meant by meaningful?
Well, that's again, that's another lawyer's dream.
Yeah.
That depends, and we have to argue.
Has there been any case law or anything that...
There's a bit of case law on it, yes, Mr. Chairman. And it's invariably it's been, say for the sake of argument, the individual who posted the tweet has got 300,000 followers, and if I could use, this is referenced here in this area, 300,000 followers, and we can identify them, and if we can show X percentage are based in Northern Ireland, then that would be, that would get us over the threshold there for that. But you do have to prove that there has been publication.
And again, this is something that's sort of subject to debate. What meaningful means. It's a bit like sort of the serious harm test.
So if our current law is inadequate to deal with social media,
Yeah.
and this bill is inadequate to deal with social media,
We do.
what is the answer?
The answer is there has to be unified legislation, preferably jointly across Europe. And I'm not talking about EU as such. I'm talking about, countries have got to get together on this side of the Atlantic and get a common policy. The Ecom directive needs to be amended to remove the perceived protection. And again, I dispute that they do have protection under that. But having said that, obviously, I'm stating their position, if you like. But there has to be some form of legislation. Now, the online harms bill is being debated. There's one being debated in London and one being debated in Dublin. Originally, the Prime Minister had indicated for here that there was going to be criminal sanctions against directors of the social media companies.
Yeah.
I don't know, it's just maybe there was a typographical error or something. I couldn't find it. It's gone. It seems to have disappeared from the bill. So it's a fine they're talking about. And again, people are going, a £10 million fine. It's nothing. It's nothing to them,
But in terms of this committee, we have this bill in front of us. Some people like it, some of us don't, etc. But is there any way in which it could be amended in the social media context to give it actual bite?
Yes, I think it could, certainly, if the committee were prepared to amend Section 5 to state categorically that social media and search engine giants will be regarded as publishers if they do not. I mean, give them an innocent dissemination defence, like one bite at it, because any more than that, it's too late anyway. It's all around the world, so you're looking for damages.
So reverse the idea that they're a mere platform.
Correct.
Treat them as publishers and give them the one bite defence.
Yeah. As an innocent dissemination defence, absolutely, and that I believe, based on the current law as it stands, is the case. They are disputing this, but I believe that is what the law stands for at the moment. You give them notice, give them an opportunity, and act. These companies, I believe, have algorithms to deal with a lot of this stuff. They can prevent, and it needs to be prevention. The longer term game has to be to prevent them doing it. But provided we can put legislation in place that lets them know that they are treated the same as the mainstream media. They're taking the advertising from the mainstream media. They're taking investigative journalism from the mainstream media and not paying for it. And yet, the mainstream media, they don't seem to get that what they're doing even here, they're making it easier for the social media and search engine giants to actually continue to do what they're doing.
Yeah, Paul, the online harm bill that's going through at the moment, that Northern Ireland would be subject to that as well, wouldn't it?
I assume that we will be included in it. Again, I'm not absolutely certain, but I was assuming that there will be.
I think we've asked to get some clarification through the Secretary of State just to make sure that is the case, but I haven't heard anything back yet.
I can't answer that question. I'm sorry, but I mean, I was assuming that was the case.
Okay, sorry, Jim, any more?
Just one other point.
Sorry.
Some of the supporters of this bill say, if we don't follow the 2013 Act, we are going to lag behind in jurisprudence in terms of the authorities coming out of the Supreme Court, etc., will be of no applicability and will be left floundering on our own. What do you say to that?
Well, first of all, you'll be left floundering with Scotland. So I mean, they're not following by the nose. I think that's absolute nonsense. Absolute nonsense. We've got our laws. Many laws in Northern Ireland are different from England and Wales, different from Scotland. This here has been the case. We've had it now for 8 years. I haven't seen any problems arising in the intervening period, nor do I anticipate any arising. The law is very simple. The law should be kept as simple as possible, both for the purpose of administering it effectively, but administering it clearly so people know where to stand. But this scenario that we are in, I mean, to be frank, most of this, the debate on this, it is totally outdated. Mm-hmm. Mike Nesbitt, I know he's doing his best here. He's also a client of mine, so I've got to be very careful what I say. But having said all that, it's not. This is for maybe 2010. Mm-hmm. We're 2021 and rapidly approaching 2024. It's totally outdated. It's not fit for any purpose whatsoever, and it's not doing the mainstream media purpose. Sam McBride will tell you that his book, which he's very, very upset about, that he got a lot of letters. I want to make it absolutely clear, he didn't get any from me, just in case he doesn't make that clear to you, but he was very upset. He said he was peppered with letters. This is not going to stop lawyers sending letters to him. This isn't going to stop. They're still going to send the letters because it's all pre-litigation. And unless you're going to introduce, the copyright legislation or something where a lawyer is penalised if he puts somebody in notice and fails to follow through, which isn't going to happen, I hope. But it's not going to make any difference. It's not going to help him. And he doesn't seem to get that, and I think it's vitally important. And the other question I would ask, and I'm not sure, and I've debated with Sam quite a bit, and as I say, a lot of time for him. BBC are going to say the same, by the way, that they get these letters in. I could tell you a thing or two about BBC Northern Ireland, but I'll just not go there at the moment. You can read my book next year. It's coming out, and we'll see about that. But this is not going to make any difference to that. None whatsoever. And it'll give them an opportunity. They can rant on like I am here for an hour. But
Thanks, Paul. Alicia?
Back to roll. You're very welcome this afternoon. Again, to just homing in on this serious harm, but I have to compliment you on your presentation because when you make that point that the law is there to be easily understood, I was able to grasp everything, in fact, that you were saying, and the emphasis that you were placing on different areas in that of it was very, very good.
Thank you for saying that. I must tell my wife, she says I speak too quickly and nobody understands me, but at least it'll be my day.
Well, just you're you are in the land of hot air here.
Again, and that area of serious harm, and particularly for the defence of the man on the street. And given that it's not that objective, say, in deciding just exactly what serious harm is, and that even in his case, he's the person probably more than anyone else that knows the extent of the harm, and whether or not it's given the same emphasis then, we'll say, by the courts. That where it brings me to the question, just when you had said about a judge, maybe from a totally different social class in every respect, and that as well too, is he really well placed to make that type of judgment?
I think those are, again, very good points. I think, to be fair to the judiciary, they do get to the bottom of it, and I haven't had any bad decisions that I'm aware of that way. To be fair, they do to think it through, but you have a very, very important point here, and it's the point that I've been trying to emphasise. Serious harm depends on the impact on the person concerned, and most of the people, in Northern Ireland, they can't afford. I advise them against, when we take on probably 2 out of every 10 inquiries that that would come into us, we'll try to take on. But most people can't afford to have this debate. Look, Judge, it's different for me. This has absolutely ruined my life. My children aren't speaking to me. It may not be serious to other people. It may not be serious harm. It's devastated me, and that is happening day in, day out. It is a problem. So what you're saying is absolutely correct. But who's going to be the beneficiaries for debating it? The lawyers. We get paid to come in and have the debate. Now, I'm lucky. I'm at a fortunate stage in my life. I don't need the work, and I'm not looking for any work. But it is something that we've got to try and understand. Why? What is going to be gained from this?
And again, too, then, and I'm sure this is something that we experience as MLAs and so on, particularly when it comes to the media, such as the radio and so on, the way that they can toss things out there, allowing the public to arrive at whatever conclusions that they do arrive at, but that in the way that the media has presented it, it has an implication that is totally and absolutely erroneous at the same time. And there doesn't seem to be any defence there then for the man on the street again, in order to confront that. And it's probably easier confronted here in the north of Ireland if costs are that much lower than what they are, we'll say, in other jurisdictions and so on. And to take that facility away from them would be totally wrong. So I do feel that this legislation really, in many respects, there to, if anything, support the media, what is moguls, whatever you want to call them, such as either those that broadcast on radio or all of the other social platforms that you talk about.
That's absolutely right. And again, no legal aid, don't forget, for people. So that's one area of law that you can't get legal aid for. And I think that's very, very important just to remember that, ordinary people, and like I say, that example I gave about with the Belfast Telegraph article, with that headline, it's just twisted. It's not serious harm. but it does twist what a politician says, you know. I mean, or what, you know, if somebody has a comment, it's all how the media portray that, the emphasis they place on it, the context that it's published in. I mean, the media have great power. And, you know, it's not, I mean, as I say, we are, I mean, sometimes there's one particular publication that, you know, the word, all their journalists, and I act for many, many journalists, or the journalists and politicians and lawyers would be, you know, form a major proportion of my clients. But one particular media outlet, the words are, you don't mention my name, you don't give Tweed the oxygen of publicity. And you probably think, thank goodness, and the way he's talking here, that's no bad thing. And it would be for my own self-interest to have the publicity, because that would advertise. But is that right? Is that fair to do it that way? I don't want anyone to answer that, please. Okay, but that's an example of the part. It's just the point that you're making in terms of, you know, an MLA's comments. It's how it's put out there. Yeah. It's the media give their interpretation of it, and once it's out, it's very, very difficult to set it right. Particularly if you do not have the financial wherewithal to take these on. And I say Stephen Nolan, you know, was very, very clear. He made that point. He said, "Look, I'm in a fortunate position here that I can go after the anonymous trolls, because I've got the funds to do it." Not many people are in that position to do it.
And just finally, I know that the same point has already been broached in relation to Section 5 and the publishers, not a mere platform as such, but where they could be held responsible in that respect. But the question I intended asking, you see that as opposed to, we'll say, this legislation, what other legislation could one sort of develop or implement? And I know that you already alluded to the fact that it needs to be sort of like a European-wide strategy in a sense, and that in what way can anyone come forward, we'll say, with legislation locally that would contribute to that European debate even?
Personally, I would be pushing for a new Communications and Decency Act. Get it in there, start from scratch, make it applicable to the modern day, make it applicable to the 2020s, and I would obviously start by making it absolutely plain that social media and the search engines are responsible for their content, subject to that one opportunity that they have, you know, what's currently the Section 1 innocent dissemination defence, give them the opportunity to take it down, put pressure on them to get algorithms in place, impose a duty of care, which the Online Harms Bill is proposing to do, but the duty of care should be right across the board. I believe they have a duty of care at the moment. I believe they have a duty of care, you know, whether it's Instagram, where, you know, young girls have been slashing their wrists because of the bullying going on online or whatever. I do believe they have a duty of care, and I feel very strongly about that. But we get it codified into pan-European legislation, and we do it. We're never going to get agreement with, for instance, the United States, because already, like for instance, Facebook are trying to get all the data shipped out to what they regard as a safe haven of the United States. And to be fair, the Irish Information Commissioners holding firm and trying to stop that happening. But, you know, that is a problem we have. Google are just, like, they are so powerful. It is like, I don't really know what we do here. We may be at 2024 already, you know, I just don't know. But certainly I don't think we should make it any easier.
Thank you.
No, thank you.
So just, it's interesting, Paul, you mentioned there sort of Communications and Decency Act. You wouldn't sort of let the committee know, sort of not now, but if you would like to write to the committee with some of your views on that, that might be quite useful for our deliberations, and particularly where we move forward on this as well.
We do, certainly, Mr. Chairman.
Thanks. Matthew?
Thank you, Chair. Thank you for your time today, Mr. Tweed. Apologies, I was slightly late for the beginning of the hearing, and also I'll declare an interest because I'm the chair of an all-party group on press freedom and media sustainability. So thank you for written and oral presentation today. And I don't disagree with what you've said in relation to the power of the social media companies, tech companies in general. I think this is one of the biggest, one of the biggest challenges of this century in terms of how we manage privacy and a whole range of other things that they have not been a positive influence on. But I suppose I'm interested in you seem quite confident that these reforms will not help local media here. Rob, before we get on to social media, I'm interested in local media because they're under extreme pressure here. Lots of our local papers obviously don't have very many staff anymore, and those staff that they do have are paid usually relatively modest wages to report in things like courts and councils and and they're under a lot of pressure. Most of them are in favour of some kind of reform of our defamation law because they feel that there is a chilling effect, or they believe they feel chilled. And are they wrong?
I believe they are wrong, and I should say I act for a number of the local publishers in both Irish jurisdictions, although I don't speak for them, and you've summarised their position very accurately. They're all of that view. I've tried to explain to them that this is not the answer. Right. They will end up paying more in legal costs than they will be paying in damages. And as far as we're concerned, certainly in Northern Ireland, I don't believe there is a problem as such. I take the point that they're all very, very up in arms about getting letters from lawyers, etc. But this will not answer that problem. Yeah. It won't. But I think all I can just say, look, this is my view. I've got to be very careful in the same way. I can't go too hard in the bill because Mike Nesbitt's a client of mine. I'm sort of hampered by what I can say because of the local media, their position as you've outlined. But, I just urge them to think about what they wish for. This is not the answer to it. I'm probably the arch hypocrite of our times, because I'm now taking upon myself to try and protect the print media, because I love reading papers. I don't like the online stuff, and I probably buy more newspapers than anyone else in the province, not just professionally, but because I enjoy reading them. And it would be an absolute tragedy if I lose them. But what is happening here is what they are wishing for is playing into the hands of Facebook, Google, and the other online giants. And because what they've got to concentrate on is to put themselves in the position where they can, maintain their current status. They can pull back on the advertising, get their advertising in, maintain their importance, and try and avoid a situation where they're having to, pay out high levels of legal costs. I mean, there's a tendency here to bring in legal counsel. I mean, for instance, we had a case we fought, and it could have been settled very early on. And the local newspaper, they brought in Sir Edward Garnier, the former Solicitor General, to take us on, and also a barrister from London Chambers, plus English lawyers. When, A, the case could have been resolved, and B, and ultimately was, but they've got to try and... I just can't seem to get it across to them. They need to try and look at this. And yes, I agree with this. It's a big, big problem. I mean, I act for many, many journalists. And, they're absolutely first-class people. And like I say, we emphasise about Sam McBride. I have nothing but the utmost respect for him as an investigative journalist. But it's just they don't seem to be following a logic. They're just following this old mantra about libel tourism. So that's gone. Well, we couldn't get any examples of that. Then it's protected. They need to protect themselves. But they need to do it in a way that's going to be tangible, that will protect them from social media. Social media and Google are their enemy, not the libel lawyers.
I mean, I agree that social media is their enemy in terms of cannibalising content and all that. I think that's true. But I suppose, to play devil's advocate, someone might say that's a separate issue in relation to content, in relation to how content's paid for. But you've talked there about sort of, I guess, out-of-court settlements, and sometimes, if my terminology is wrong at any point, you can correct me, but you talked earlier on about pre-litigation letters. Would someone be wrong if they said, well, the use of those might in itself be an example of the defamation law gone wrong? Because if people are willing to or advised to settle out of court really quickly, it's proof that they are too afraid to allow the courts to test the law, because the law is either too stringent or perceptions of it are too stringent. So there's a proliferation of out-of-court settlements, which is in itself chilling.
Well, first of all, I don't think there's a proliferation of settlements, or maybe I'm not involved in all the cases.
I don't know if there's
I think the point you're making is, the threat, like a letter from a lawyer, is that a threat that encourages a settlement? I think that's the point that you're making. I mean, my answer to that is, if you're publishing the truth, you've nothing to fear. You've absolutely nothing to fear whatsoever. If you're sure of the facts, and if you're not sure of the facts, so delay publication and do the checks that you want. One of the scenarios that I find fairly frustrating is that a journalist can sometimes take a couple of weeks researching a story, and with the intention of, say, running it on the Sunday. And then the client gets a raft of questions on a Friday night, sometimes Saturday morning, saying, I'm going to publish this within 24 hours, here are the questions answered. Now, that's where the problems arise, because the client isn't given, the subject isn't given an opportunity the same time as a journalist to research it. And, that's the sort of thing I would oppose. The letters coming in, as I say, I don't certainly agree with letters being sent that have no legal basis or no legal concerns. You do have to remember, and you might want to ask Sam whenever he gives evidence, one thing I don't know is, were these letters that he received about his book, were they relating to questions he had put to the potential subjects prior to publication, or was it about actual statements he was putting in the book? Because if there were questions, sometimes you get a broad question, from a journalist or an author, and it causes all sorts of things. It could cover everything, and you'll get a reply back from a lawyer saying, "Look, I just would ask you to be very cautious here. Would warn you to be cautious here. If you publish an inaccuracy, we'll sue." There's a big difference in that and somebody trying to actually stop the book. The truth is the biggest sword of defence that any journalist can have.
Are they more likely to, but on this point about the truth, are they more likely to be sort of in a jurisdiction where, this is sort of putting this to you, in a jurisdiction where, for the sake of argument, say England and Wales, there's if there is, as advocates of it would say, a clear harm test to be tested, that can be tested in court, where there's an allegation of defamation and a writ's been issued, that because that clear test for the court exists in law, the journalist and the proprietor of the media, the publisher themselves, are more likely to say, hang on, we're going to stand behind this story, we're going to stand behind what we've published, and go to court because we think what we've published is legitimate, than in Northern Ireland, where, by certainly accounts of the media, the law is less clear in terms of what that harm is. So they're more likely to have a chilling effect. They're more likely to say, well, let's just, at the first sign of a legal letter, even if it's not, as you say, a letter grounded in substantive legal arguments, but rather a kind of, watch yourself, we're a bit annoyed letter, they're more likely to just sort of either settle out of court or actually not publish the thing in the first place because it's not worth the hassle.
Well, certainly in terms of the position being clear in England, the answer is it's not. Just again back to this point of what's serious harm. Costs are front-loaded, so the ordinary litigant, if they have been genuinely harmed, and if they're in the right, they've got the costs. They're knocked out in one, so they can't do it. So it's getting that balance for media on one hand, where there's not the threat, and basically what you're saying. I mean, a lot of the small publishers in Northern Ireland do not have insurance, so they can't test serious harm either. They're in no better position than the subject of an article. So that's not the answer to me. And serious harm, as I say, I've had it now for 8 years in England, and I still don't know what it is. But as I say, I'm maybe not the brightest, so it's maybe my fault there. But that is not the answer. I'm afraid it doesn't provide that solution. And I do take your point. I mean, you have a very valid point you're making, but the solution for it is not. And it's perhaps not an obvious solution, but it's back down if the journalist is certain of his facts, and he should be, because I'm very proud of our newspapers in both Irish jurisdictions because of our defamation laws, because they're careful and we can believe what we read. In most cases. In the United States, you can't believe anything because of First Amendment protection and the difficulties in suing. They can write everything. So therefore, somebody reads something in the United States, let's go, well, yeah, right, maybe, yeah, no, not really, or whatever. Here, we believe the media are publishing the facts, the truth. May not agree with their opinion columns or op-eds, but the truth. And I think that's very, very important. And that is due to our defamation laws in part.
And just on the specific question about libel tourism, which obviously you don't, if I'm reading you right, you don't agree with, you would reject that suggestion. In your professional experience, would you have ever advised, now, obviously you can probably explain where it's possible in any case, but where it is possible that you can litigate here or take proceedings here rather than in London or another jurisdiction, have there been any situations in which you have advised people to do that yourself?
There are no cases of libel tourism in Northern Ireland. There are none that I'm aware of. I've challenged the media to give me just one example. Over all these years, and they've been goading at me or whatever, and they've decided there are none.
Right.
They've admitted. And again, I would obviously, the committee will investigate that from others who are in the media, and I would stand to be corrected. But I've asked somebody to tell me. I certainly don't know of any. In relation to whether a Hollywood A-lister, for instance, could bring a case in Belfast, the answer is yes. if the Belfast Telegraph or a locally based newspaper publish a false allegation about somebody who has an international reputation, of course they can bring the claim here. Why shouldn't they be able to? Of course they can, but it hasn't happened.
Would it be possible, and has it been done, to say to someone who is, and again, if this is wrong, tell me, but the Sun, obviously all the UK national titles published in Northern Ireland, sometimes with slightly, bespoke local editions, but would it be possible if there's a story in the Mirror, for the sake of argument, or the Sun, and you want a quick outcome for, I'm not saying you, just like one wants a quick outcome for a client, is the scenario in which you write to the publisher and say, well, based on, we are confident that if we took proceedings in Belfast rather than London, that we would that you would be in difficulties, and therefore we are, we would like to have a conversation about how you respond to this, i.e., leading up to a kind of out-of-court settlement. Is that a plausible scenario? So it doesn't have to be libel tourism, as in a writ is issued for for proceedings in Belfast, but you're effectively kind of you're
threatening Belfast as opposed to London. That could happen. It could possibly happen. At the end of the day, it's against the scenario that I've described earlier. There's no advantage. I mean, to me, Belfast is my last choice as a libel lawyer. Absolutely my last choice. From a financial perspective, London's my first choice still. Dublin the second, but Dublin's now become more of my first choice because all Google, Facebook have all got their EMA headquarters in Dublin. In terms of me saying to the Mirror, look, okay, if this escapes into Northern, if you disseminate this article in Northern Ireland, I'm going to sue you in Belfast. It depends. I've got to act for a client with a reputation in Northern Ireland. So normally it has to be a local person or an international person with a reputation. Hasn't happened, but if somebody has got a basis for doing it, and if there is sufficient publication and sufficient damage to their reputation in Northern Ireland, the courts in Northern Ireland are just as capable as the courts in London or the courts in Dublin in determining a case.
But would it be fair statement? This is my final question. Would it be a fair statement to say that the economic activity? So your argument, yes, London is a global financial centre. Dublin is increasingly a global and at least European tech centre. So there's bigger and more important economic activity happening in both of those places. So that and obviously London's a very established legal centre as well. But Belfast, there is maybe the libel law, the corpus of libel law is a wee bit more favourable to the litigant. Would that be fair than in those others?
In theory, it would be more favourable to the litigant in Northern Ireland. In theory, but in practice, as I've explained, it doesn't. It's just it's all down to the balance between the legal costs and the damages. Okay. But you could work it around wherever you want. But the damages are probably likely to be lower because the damages here are possibly likely to be lower because it's smaller. I don't think that would be right. No, I don't think that's right at all. I think it's just, it really depends. I mean, it is so difficult to generalise in all these situations. All I can just say is that, the facts speak louder than words. We haven't got people coming into Northern Ireland. Obviously, there has to be a basis for doing it. We sue Facebook in Dublin because that's where Facebook are. Facebook Ireland are based in London and in Dublin. We have a scenario when people have accused me of libel tourism. There's a well-known Hollywood celebrity who was suing an English edition of a German publisher book, and it was published pro rata the same number of times to the same pro rata population in Dublin as it was in London. And I take the view that the courts in Dublin are just as capable of deciding it as they are in London. So that was not a libel tourism case, even though there were suggestions that it was. But this is down to the point. I mean, you gentlemen have got the owner's task, and it is a lot of responsibility in deciding whether this defamation bill is going to, whether it's fair and appropriate to introduce it, whether it's going to benefit the people of Northern Ireland, and whether it's going to benefit the traditional media, the mainstream media in Northern Ireland. And my answer is a firm, absolutely no. Absolutely no. I can see no basis whatsoever for it. And that is my personal opinion, and I stand to be corrected.
Jim?
Mr. Tweed, the wonderful thing about being in this chamber is that when that red light's on, we've got privilege. It means that people like yourself can't sue us, and I'm not going to say anything outrageous, I'm going to assure you. But it does mean that it's perhaps the only time that someone in my position is safe from someone of your experience.
Here we go.
But it's important not to abuse that right, of course. Your reputation is well known. You say that only 5% of your work is actually based in Northern Ireland. But would I be right in thinking that that 5% is the vast majority of cases involving libel in Northern Ireland?
I don't know, Mr. Wells. I can't actually answer that. I just don't know. I mean, my work would be the work I'm doing. Certainly in the recent times, would be very high profile, and so perhaps it might get what might be regarded maybe a disproportionate media coverage. So it appears if I'm doing, much more. I can't answer the question. I just don't know. I mean, there are many other good lawyers out there. I've never held myself out to be the best lawyer in the world by any means. So, but I could count with one hand the number of cases that I've got in Northern Ireland at the moment. I certainly couldn't do that as far as Dublin or London are concerned at the moment.
Because the layman, the market's cornered by yourself and your colleagues.
Sorry?
You've cornered the market in Northern Ireland.
Again, I think there are quite a few other lawyers out there doing media work. I think so anyway. I don't know.
They're very quiet. They are.
Well, I just don't know.
Right.
I can't answer that. I would be misleading you if I said otherwise.
What I'm trying to work out is your motivation in coming here and saying that Mr. Nesbitt's bill has very little merit. We've got to keep things as they are. Things are going well. I'm doing very well. My colleagues are doing very well. So let's not upset the apple cart. When things are going good, just keep them as they are. Surely, given the fact that you're so successful and have so much work in Northern Ireland, in the sense that a very high percentage of the work seems to fall in your lap, is that not your motivation for saying let's not change things?
Absolutely not, and I really resent that comment. Nothing could be further from the truth. I would not, and I'll state publicly, I don't care when I don't get another case from Northern Ireland until I retire. I do not make money from Northern Ireland work per se. I take on cases I believe have merit, I believe they're right, and I just don't like being bullied, as I have been by certain quarters here, and if you bully me, I'll come at you. And that's my modus operandi. And I'm not going to take it that I'm here for the money. That is the one criticism I will not take. You can call me a useless lawyer. You can call me somebody who's going after inappropriate cases. But I'm not in it in Northern Ireland for the money. I can tell you that categorically.
No, and I wouldn't accuse you of that at all.
Yeah, well, you are, Mr. Wells. You're actually saying, you put it to me, my cornering the market so that I can make money here. That is absolute, total nonsense. Nothing could be further from the truth.
But it's not libelous of me to say that you're cornering the market, because that's an indication of the success that you've had and your notoriety, that many people will come to you for work because they know your reputation.
That's possibly right. You can tell me that. I don't know.
Why I'm saying this is that you quoted the Arlene Foster case and the excellent judgment there was in that, and I think well done to you for what you did there. But the fact that you took that work on in Northern Ireland, that was broadcast throughout the United Kingdom and much further, that success you had in that case.
Yeah. Well, no, sorry, do you mean, am I getting success from my client's success? Or getting, I mean, the answer is yes to that,
yes.
Of course.
But what I'm saying to you is, that case was broadcast, not just in the Northern Ireland media, but throughout the United Kingdom and the Irish Republic.
Yeah.
That success, right? That is bound to have helped your work in the rest of the UK, that success. Bound to have.
It probably does. But like I said, I'm not looking for work. I say we're turning away more and more work. And as I say, I'm putting that in the public record. I'm not looking for work. And, but I will fight till the death for a case that I believe, that is a right case, has got merit, and that is what I'll do. But the bottom line on it is, Belfast is not an attractive position, particularly for me. Certainly from a financial perspective, it most certainly is not. But in terms of, if you're saying to me, look, you're getting a lot of attention from doing particular cases, I fight the case, and I get a result. And yes, if I get publicity from it, great, that's fine. It's good for the client. It's for the client. I'm trying to do it, but I will also do. At the end of the day, I'd be a total hypocrite if I said otherwise. I love the hunt, and it is good to get an acknowledgement at the end of it. But as I say, this and this is where people have, and I apologise if I'm sounding sharp, but I'm very sensitive to this criticism about the staying in Northern Ireland or attracting work to make money in it. Not in this jurisdiction, not for a media lawyer. And I've made this very plain, even in the Defamation Committee that we've discussed in the High Court in Belfast. It is virtually impossible to make money here in Northern Ireland. There are various factors that explain that, historic factors and otherwise. It will change, and if this legislation is brought in, we're brought in the level of thing in Wales, yeah, I might actually come in and stay around maybe for another year or two and capitalise on the increased fees. But it's not in the interests of the people of Northern Ireland.
Now, you're saying that you don't like Mr Nesbitt's bill. Certainly, we've got your drift on that. There's no doubt about it. But you're saying that changes is required in Northern Ireland. A change is required in Northern Ireland to take account of the social media. That the present legislation is inadequate.
Totally.
Now, the question is can Mr Nesbitt's bill be amended adequately to deal with that, or do we need to go back to scratch and start all over again with a totally new bill to replace the present legislation in Northern Ireland?
If you're asking my personal preference, new bill, start from scratch and run it through and deal with the matters, the things that matter to both the people in Northern Ireland and the mainstream media in Northern Ireland. They get the bill, they get it properly structured. The 2013 Act, in my opinion, is totally outdated. It is not fit for the purpose that it was intended. There was a massive pressure at that stage to placate the media, to be seen to be doing something. And I'm just urging, not here, but to answer your question, Mr Wells, yes, I would prefer to see if the committee and the Assembly are prepared to take on social media and deal with a problem of our times, a real problem of our times, I would absolutely welcome that with open arms. But I don't see any point in trying to amend around this for the very reasons we've discussed in terms of serious harm. You've got my views on that. I don't see any real point in it. It could be done. But that's, and I mean, in terms of, changing the descriptions, the honest opinion, truth, and whatever, again, I have no particular problem with that, if deemed appropriate. But I think we've all got to just ask the question, why, what benefit it's going to. We don't want to do change just for the sake of it, in my respectful submission.
Okay.
Thanks, Jim.
Thank you.
Okay, thank you, Chair. And thank you, Paul, for your information so far. And there's been a lot of good questions, a lot of good answers, I might add. Do you think there is not free speech in Northern Ireland from the mainstream media?
I would just put that article up again. I mean, that's the Belfast Telegraph giving their opinion on defamation law reform. Totally one-sided, one way. They've left them. I mean, if that's not free speech, I don't know what it is. There's total free speech. I mean, I have absolute sympathy for a situation where, journalists, if they feel themselves in some way threatened in the wrong by some billionaire who, has just decided, look, I'm going to try and take you out. I'm going to use my money to knock you out. And that's something that needs to be dealt with. And I've been acting for publishers in situations like that, and we've got to fight them. And it's not satisfactory. And that is something that, but I'm not aware of any cases of that nature within this jurisdiction. And if it does become a problem, or if it did become a problem, I think it's something obviously needs to be looked at. But unless, as I say, and again, I stand to be corrected, I'm just giving you what I know. I mean, I'm assuming I'm right in that, but I'm not aware of any instances of that, or of academics or scientists being threatened. But again, I may be wrong.
You refer to the truth on many occasions about telling the truth, journalism, telling the truth. Is journalism anything to be concerned about if they're telling the truth?
In terms of
you sending them a letter?
Well, again, if I send them a letter, I don't just send out letters.
No,
I work through, and I try to work out if my client. I have to assess my client because we're under very strict regulations as well. Not that I need them, and I try to work out. We have many clients, and we're actually a great filter for the media because we send away a lot of cases where if they can't persuade me. That's at least, well, hopefully they're not going to somebody else or whatever, but it is difficult. I can't get it right every time, you can't be absolutely certain, but you do your best to assess the credibility of the client that comes to you, and if you're satisfied that there is merit, then you decide whether to take action and put them in notice. But I have a very good relationship with most of the in-house lawyers in the UK and Ireland. I lift the phone to them. We try to get it sorted. Most of them are very, very capable people, brighter lawyers than me, because they have much more experience, because they're doing this, day in, day out. And we normally, in most of the cases, we can reach agreement. Most of them, whether it's a Mail Online, the Sun, or whatever, we'll have a chat, we'll get it sorted. I say, look, you need to speak to the journalist. Here's this stuff. Would you take a look at it? It's not for publication, but I'm letting you show this will prove that my client is telling the truth in this bit here, and we'll get it sorted. And a lot of my clients, it's not money. It's not about getting, a Klondike and damages. Not all of them, anyway, but most of them don't. They want to get the record set straight, but they want it done quickly. And this is another problem, even with the mainstream media. It is a problem, not as great a one, obviously, in facing the dissemination of the likes of Google, but it's trying to get them to correct it right away. One of the single biggest problems I have is that an article is published, and you persuade the in-house lawyer, look, that's factually wrong. I can prove it's provably wrong. You say, Paul, check with them, you give me that, great. We'll publish a clarification at the end of the article online. Now, how many people are going to read down the article a second time to find a clarification at the bottom? And is that better than the mail postage stamp apology that we had back in the 1980s? So it is balance, and I say, and I keep quoting back to my great friend Liam Clark saying about we don't have to be balanced, but there has to be fairness in terms of it. So in other words, if something is published wrong, there must be either, and we can consider in Mr. Wells, when he was saying about the legislation, consider putting a clause in there if a newspaper is found to be in the wrong. They've got to not only take the offending article down, but they've got to publish an apology with the exact same prominence of the article that has been deemed by the courts to be wrong. Bearing in mind that it takes a year on average to get a case to trial here. If we get to say, how many cases have we had that have come to trial in Northern Ireland? I mean, how many? In Dublin, it's taking nearly 2 years to get a case. London's quicker, but then the costs are at that stage, people's hands are shaking to see the level of legal costs. Mm-hmm. So there are no answers to any of these problems that are just that there's a general clause that you can put in, but I keep reiterating and emphasising. This is not me speaking for claimants, and I'm not speaking for the mainstream media either. But this is not. Everyone's got to understand. This is not just this is not the current legislation is not just in favour of plaintiffs. It actually, ironically, is in favour of the mainstream media as well, in that the legal costs are so low, and that most of the lawyers, I mean, the in-house lawyers who deal with these cases, they know whether they can defend a case or not. They know right away, most of them. So and it's not it's while in Northern Ireland, I'm just thinking aloud, there would be most of them will have access to legal advice. Experienced lawyers who are dealing with this day in, day out. So it's not just a question of a journalist, being exposed. Now, Sam will say, well, look, no, when I was doing my book, I was on my own. And to be fair, he may have a point there. But this is not going to help him.
Yeah. Okay, thank you, Paul. Thanks, Chair.
Gemma? There we go.
Thanks, Chair. No, you're okay. My question's been answered.
Okay, thanks very much indeed, Gemma.
Thanks, Paul.
Pat?
Hello.
Hi, Pat. Come on.
Hello. Listen, thanks very much, and thanks for calling me in, Chair. And thanks very much, Mr. Tweed, for your evidence. I have only just one little small point, and it's just when you were talking to Mr. Wells there, you had said that we should go back to scratch with this bill. Northern Ireland's a very small jurisdiction, but earlier on in your deliberations, you said that Ireland, England, Scotland, Wales, the EU, and probably all of Europe should get together in order to try and strengthen the laws to take on social media. Would there be a point in going back to scratch on this bill to try and amend it for Northern Ireland with already what you've already stated earlier by trying to get all countries together on it? Thank you.
Well, yes, obviously the preference would be to get, at least a pan-European agreement. on dealing with these issues, and that would be by far the preference. And it is being considered, I should say, at the moment. I mean, they are looking at it, but that would definitely be the preference, certainly from my perspective. And in terms of effectiveness, because you have to bear in mind, we're having difficulty at the moment, for instance, trying to pin down where Amazon Prime are based. Now, the broadcast here, is it Luxembourg, is it Dublin, is it London? Where? Those are all things, whereas if we had a pan-European approach, that would be the ideal situation. Whether we need any legislation here, as I say, unless it is to deal with the social media companies. And again, I think you have to be realistic here, given that they are jurisdictionally based in the Republic of Ireland. We have to consider whether that is worth, whether it's worth the time that would be required to be put into this, whenever there are so many other issues, pressing issues that the government is facing at the moment.
Okay.
But would it not be more helpful and beneficial for ourselves? Look, I know the social media side is very difficult to do, but in order to work, within where we are and work on this bill and try and strengthen it, at the same time, try and go for that broader pan-European bill, which would cover probably all jurisdictions.
Yeah, I've no problem with that. I mean, if that's a solution, as I say, subject to the observations I've given in relation to the specific clauses in the bill. But that certainly would be something to be considered. Yes.
Okay.
Okay. Thank you, Chair. Thank you,
Thanks, Paul. Thank you very much indeed for an excellent evidence session. You were going to send us some of your ideas on the Communications and Decency Act. If you
legislation, yeah.
The online harms, no.
Yes.
You can do both. I mean, if that's
yes, please. Thank you very much indeed.
Happy to do that.
Thank you very much indeed for your time, and thank you very much indeed for giving the committee a lot to cogitate over.
Sorry for talking so much. My wife will be complaining when I go back here. But
don't worry, that's what we do in this committee.
I'll just leave that there for you.
And if you could leave that there for us as well. Thank you very much indeed.
Thank you.
Cheers. Thank you.
Chair, does the committee also want to write to the Minister for the Economy just to determine the applicability of the online harm bill? Is it reserved? Does it apply to Northern Ireland, etc.?
I mean, it's it's a different. Well, obviously, defamation law is obviously devolved, as we're discussing today. Communications is reserved.
Why did it come up?
Minister for the Economy, because that's who it would sit with. I think we get correspondence from Ofcom, somebody like Ofcom, telling us about the online harm bill. I asked my colleague in the
Ofcom sits within Economy, does it?
I think so. I asked my colleague, the clerk of the Economy, and they said they were aware of the bill, but I didn't ask them at the time whether it was reserved or not, so we could fire off about it then to the Minister.
Yeah, communications generally is reserved, isn't it? I mean, like...
Yes, under matters of Ofcom, but I'm not quite sure about this because it would stretch into sort of defamation and libel, won't it?
So the sponsor of the bill, if I recall correctly, spoke to the Secretary of State for Northern Ireland about whether he could include the parts about the online, about social media. So there is some question then about, is it reserved, is it not? So we get clarity then from the Minister of the Economy.
Yeah, let's write to the Minister of Economy to do that as well. And is it worth copying that to Secretary of State as well?
Okay. Yeah. Okay.
Just depending on where it is and that sort of thing, but they might be. You can understand that Gordon will probably try and then contact the Secretary of State, but the Secretary of State is aware. But we might get to that point. Certainly, team. If we're just going to take a short break for about 2 minutes. Yeah, thank you.
Thanks, members. Sorry about that.
Northern Ireland Assembly, Senate Chamber, Programme Sound. This is the Northern Ireland Assembly Senate Chamber Programme Sound. This is the Northern Ireland Assembly Senate Chamber Programme Sound. This is the Northern Ireland Assembly Senate Chamber Programme Sound. This is the Northern Ireland Assembly Senate Chamber Programme Sound. This is the Northern Ireland Assembly Senate Chamber Programme Sound. This is the Northern Ireland Assembly Senate Chamber Programme Sound. This is the Northern Ireland Assembly Senate Chamber Programme Sound. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This is the Northern Ireland Assembly Senate Chamber Programme signed. This.
And first of all, can David, are you there? Hi, David.
Yes.
Hi, Steve Aiken here, just checking comms, making sure you can hear us loud and clear. Excellent. Thanks very much indeed. Okay, team, next item on the agenda, item number 7, Defamation Bill Committee Stage Oral Evidence. We will now receive oral evidence from Sam McBride, author and journalist, and David Attfield, Legal Director at the BBC on the Defamation Bill. David, are you the Legal Director for the whole of the BBC or just for BBC Northern Ireland, just for the record?
No, well, I'm Legal Director of neither. In fact, I'm Legal Director of a pre-publication team called Programme Legal Advice. So that is the team of publication lawyers who advise journalists on content pre-publication.
Okay. Thanks very much indeed. Thank you.
We have a team of 8. We have a team of 8 lawyers. They're all based in London.
Okay. Cheers. Thank you very much indeed. So, Sam, welcome. Welcome into the. You've a couple of times you've been in front of here, haven't you?
Once before, and it still feels rather unnatural, thankfully.
Well, welcome anyhow. I'm sorry, David, we don't have you here to sort of greet you in person, but thanks very much indeed for coming up in Starleaf. Team, the relevant papers are as follows. The Clerk's briefing note is on page 141. Sam's response on page 148. David's response on page 152. Sam and David, you're both very welcome to the Committee for Finance. I'm going to ask you to speak for your different submissions to the committee stage of the Defamation Bill. I want you to take about 10 to 15 minutes talking through, and particularly some of the clauses to do as we go through it as well. I'll then come in and ask you some specific questions because we're looking at clauses to make sure we do that. So the clauses, my questions mightn't quite match what sort of the way it is, but please feel free to do that as well. But I think, Sam, can you kick off, please, and then I'll bring David in when you're finished. And then after you've both spoken, we'll then sort of ask the questions to do it together. But over to you, Sam.
Thank you, Chairman. Thank you, members, for taking the time to hear my evidence. Could Could I maybe just ask for a point of clarification at the outset of this, because due to the COVID restrictions, I wasn't able to be in the public gallery, so I missed the first few minutes of Paul Tweed's evidence. I was able to pick up most of the rest of it in the cafe next door, but I picked up that he made some reference to an article that I had written. I think, reading between the lines, I discern what his complaint is, but I'd rather just get it clarified now, because I think it's fundamentally wrong, as to an article that I wrote about this issue, and an image that illustrated that, which he said had not been changed. Is that fundamentally what the complaint was, that he had said it should be changed?
As far as I can ascertain, because I actually haven't, sorry, my eyesight's not that good to see it down the other end of the thing, but
no problem.
In essence, that is, I think, that's what he was stating.
Well, I was astounded to hear that complaint, to be perfectly honest, and I can very quickly deal with this issue. There's nothing really hangs on it, but it's pretty concerning that a lawyer comes here and says something that is so fundamentally and demonstrably inaccurate. There was a complaint from Paul Tweed about that article. It was an informal complaint. It's actually, I think, the only time I've got an informal complaint from Paul Tweed, and it was dealt with promptly. My son actually was ill, so it took me a couple of days to get back to him, but it was dealt with, as far as I was concerned, to his satisfaction. He hasn't come back to make any further requests about that. And as soon as I saw his email and dealt with it, the image was altered. It is altered on the website of the Belfast Telegraph. He had complained about the juxtaposition, and I think he made a reasonable complaint. I didn't choose the image. It was chosen probably by a very junior member of staff. They certainly didn't put, I can assure you, they didn't put any thought into trying to construe something between the image and the headline. But, however, when he drew it to my attention, I think he made a fully reasonable point. However, that, if you can see my phone, is what is now on the Belfast Telegraph website. It's been there from the 24th of September, from the day that I got his email and immediately responded to it after contacting my editor. So for him to say that that remains unaltered on our website is, I mean, it's concerning that he thinks that way. But anyway, I just wanted to deal with that at the outset.
So that's very clear, and that's on the record.
Sure. Thank you for taking the time to scrutinise this bill. I know this is a time where you're under a lot of pressure as MLAs. There's a lot of legislation coming through towards the end of this mandate. I want to be clear, first of all, that despite what I just said about my employment at the Belfast Telegraph, which I hadn't intended to say, my employer, the Belfast Telegraph and the Sunday Independent, are aware that I'm giving evidence. They're perfectly happy with that. But I've joined those newspapers relatively recently. I'm not speaking on behalf of them. I'm speaking as a journalist, as an author, and so they will give their own evidence, which I think they have done in writing. So don't be construing what I say as speaking on their behalf. There will be others, and David is one of those people, who can speak more knowledgeably than me to the individual clauses of this bill and to some of the minutiae of what is a very complicated area of civil law. What I want to do, and want to do even more so after hearing Paul Tweed's evidence, or the evidence such as it was that I heard, is to convince you that there is a problem which needs resolved, because it is clear that to this day there are still some people who continue to suggest that this is really being exaggerated. There's no great problem here, and because things are fine for Paul Tweed and for his clients, as Mr Wells tried to allude to in some of his questions, that actually there's not a great problem. Well, I work as a journalist. I see this problem. I accept that Paul Tweed is on the other side of this, and there should be a healthy tension between the two of us. But I can assure you that this does exist. I think that this bill is vulnerable to somebody like Paul Tweed saying, "Show us your evidence." And the problem that we very often... Is that what you're referring to in your the evidence you send in to us, your written evidence, this chilling effect? Yes. And you sense that the chilling, and sort of, it's very difficult to prove a negative. The chilling effect of what the circumstances currently are, that acts as a brake on using any sort of process or recourse to dealing with defamation? That is, I think, the central problem, as I perceive it, certainly in my experience. It's not that newspapers, certainly, and I can only speak for newspapers, not for other media organisations, but it's not that we very often get legal advice that we will lose a case, it's that we might lose a case. And as commercial entities, newspapers will take a commercial decision. My instinct as a journalist is to defend everything that I think is defensible. I wouldn't write it if I didn't think it was was right. If it's wrong, or if I'm persuaded that it might be wrong, as was the case with that photo of Christian Jessen, of course it should be altered. I'm absolutely somebody who will support that, as my colleagues can say. But when it comes to commercial entities, they can't do what I did with my book. They can't say, to heck with the consequences, this is a matter of profound public interest, we're going to defend it. And if we go bankrupt, we go bankrupt. Because if they do that, we all lose our jobs. We lose the newspapers that we love. And so that is not a tenable position in a commercial world for those organisations. So in bringing this, there is a difficulty. In bringing this argument that there is a problem, a chilling effect, there is a difficulty because there is an insidious secrecy that surrounds a lot of these cases. They're not known about beyond a handful of people in Northern Ireland. And it is very difficult for people like me to speak freely about them outside the bounds of a chamber like this, where thankfully, as Mr. Wells said in his questioning, there is no fear of what somebody might do in terms of sending us a legal threat.
Things like the super injunctions and the other things that we know are out there, but it's a bit like, I hate to use the Harry Potter expression, but the shall not be named sort of thing.
I've got no personal experience of super injunctions. I know that there are several that exist in Northern Ireland. There are all sorts of rumours about them, so that's not something I can speak to personally. But I would like to give you a couple of examples of things where I have a direct first-hand experience of something. If my time doesn't run over, I can give you a third. I can give you as many as you want, frankly. But there are two that I think speak to two of the difficulties that we face at the moment. The first case, I think, is one of the most egregious that I'm aware of. It's relatively recent. It's from a couple of years ago. And it is in relation to a lengthy analysis that I wrote for the newspaper, where I was then the political editor in 2019, of a major speech by the Sinn Féin leader Mary Lou MacDonald in Belfast. I drew attention in that article to a series of problems, as it seemed to me, for Sinn Féin, which, in my view, as a political journalist, were not adequately dealt with in that address to an audience at Queen's University. The article ran to about 1,300 words. That's lengthy in newspaper terms. It was a full blank page of the newsletter. Its headline was, quote, "Failing to win over unionists doesn't mean Sinn Féin's charm offensive is failing," unquote. If you go onto Google and search for that article today, you won't find it. In fact, if you go into the newsletter, if you had access to the newsletter and you search their electronic archive, you would discover a version of that page which is not the version that was printed and distributed by the newsletter in 2019. In it, you would find 14 words that have been removed. The article originally contained a sentence which said, quote, "Some of the parties, that is Sinn Féin's efforts, have been tone deaf to the point that they did not appear to most unionists to be genuine. For example, 13 years ago, Sinn Féin appointed convicted bomber Martina Anderson as head of its Department of Unionist Engagement, akin to the DUP putting Gregory Campbell in charge of winning over nationalist voters." You might think, what's significant about that? That's a fairly standard comment for a journalist, for a columnist. Gregory Campbell got his lawyer, Paul Tweed, to complain in writing that what I wrote meant that he was, quote, "guilty of criminal activity and a terrorist." He demanded that the newsletter retract that article, apologise to him publicly, remove the article from our website, pay his legal costs, which were substantial, and pay him a lot of money. To cut a long story short, the legal advice we received from an eminent lawyer was that a Northern Ireland court could award him up to £200,000 in compensation for those 14 words. Costs would be astronomically more, and despite my abhorrence as a journalist and that of my editorial colleagues, the company decided to pay him £20,000 to settle that case. Nobody knows that outside of a handful of people who were involved in it, and I think most people will view that as utterly perverse. That is the reality that we face as journalists in Northern Ireland. Of course, I did not mean that Mr. Campbell was a terrorist. I don't think he was a terrorist. I could have clarified that for him very easily in print if he had wanted me to. Of course, no reasonable person would have taken that to be what the article said. Of course, what I actually referred to was his well-known provocation of nationalists. That's commonly understood in Northern Ireland. It's understood by readers of the newsletter, often gratuitous provocation. And that is an important issue about which the press must be free to write in a democracy. And of course that had a chilling effect every time the newsletter came to write about Mr. Campbell again, no matter how innocuous that article might seem. And the secrecy here is a second chilling factor. I could not have commented about that while I was employed by the newsletter. It would have been in breach of my contract with the newsletter. Even now, I would be loath to comment about that outside the confines of the privilege that I have in this chamber. The secrecy is such that I know that very senior DUP figures were not aware of that case. They were horrified in some cases when they found out about it. Even within the party that this individual comes from, there was no argument against that, in support of what he had done there. And there are politicians who have secretly used newspapers as personal ATMs for years in Northern Ireland. People who immediately look at this as a chance to get easy money, secret easy money. And I think it was very significant, and in my experience, quite unusual, that in the agreed terms of the clarification or the correction or the apology that ran in the newsletter after this was settled, which ostensibly is what this is all about, it's about reputation, it's about being public about that, it's about correcting anything that might have been wrong there. Mr. Campbell didn't want us to mention that he had got money from us. I think that says a lot about the motivation behind some of these individuals. The second case here is better known because I was able to speak freely about it and I chose to do so. It involves my book, Burned, telling the story about the RHI scandal. It was published 2 years ago. And it was unusual for me because as a journalist, the worst that generally could happen to me in the area of defamation is basically what happened in that case with Gregory Campbell. The story is retracted, money is paid out to the individual. In a very extreme case, I suppose, my employer might go bankrupt if it was a dreadful libel, but that's it. It stops there. My employer indemnifies me personally against somebody who sues me based on what I have written in my employment. In book publishing, that's often reversed.
Sam, just the indemnification process, and I think we've heard other evidence, but one of the issues, of course, is a lot of insurance companies will take it on a risk-based process, and they will weigh up the costs of the legal process of bringing in everything against what the likely return is on it. So in effect, it becomes a business and economic decision rather than a decision of legal propriety or indeed what's right and what's wrong.
And I think that is almost invariably the case with a commercial media outlet, regardless of whether they have media insurance or, libel insurance or not. Either it's the insurer weighing this up commercially or it's the accountants in the often very large company. I mean, the newsletter was owned at that point by Johnston Press. They own several hundred newspapers across the UK. This was a very small part of their empire. The people that owned the newsletter at that point, and they've changed since then, didn't have any skin in the game. It was just numbers on a page to them, and it was about probably somebody's bonus somewhere that they could keep costs down, and if there was the risk of this running to maybe £1 million or whatever, if it went to trial in front of a jury, that was something that seemed attractive to them. Pay £20,000 plus costs, get rid of it, that's it, happy days, we can move on. And so that was the calculation there. So when it came to my book, the reverse was the case. I signed a contract in which I indemnified the publisher that there would be no libels in the text. And so there was a situation where even though it was possible that and I certainly hope that my publisher would have stood behind me in those circumstances if there had been a claim, there was no legal guarantee on them to do so. In fact, the reverse was true. I had legally guaranteed them that I would foot any bill that happened to arise from anything that was judged to be defamatory. And so several months before the book was published, I put questions to 5 senior DUP figures: Arlene Foster, Timothy Johnson, Andrew Crawford, Peter Robinson, Mervyn Story. Some of those people were asked questions about incredibly serious allegations. Others of those were asked about really, frankly, almost trivial matters. They were important to me in getting the book accurate, finding the date that somebody was at a particular meeting, what they did, where they were, things like that. But they could not in any even wide appreciation of what defamation law allows for being judged to be remotely within the bounds of defamation law. And immediately I got a response from a solicitor for those individuals who said, quote, "In the event that publication of inaccurate and defamatory material occurs, our clients are fully prepared to issue appropriate legal proceedings, which will of course include the publishing house as a co-defendant. Please take careful note of the position in this regard and notify the publishing house accordingly."
From Sefcovic. Sorry, we're hearing a bit of
You're
breakthrough.
okay.
You're being broken through by what sounds like Maris Sefcovic, so I don't think that's...
I think that's the first time that's happened. I was in a situation where all my earthly assets would have been grossly inadequate to cover even one of those individuals taking a libel action. There was the possibility of 5 separate legal actions if they had followed through on their threats. Some of them I knew to be really risible threats. They didn't have any basis in law. It was simply an attempt to put pressure on me. But some of them, I wasn't to know what a court was going to say. I wasn't to know what a jury was going to say about this. There have been perverse outcomes in libel actions in Northern Ireland before. And so I was facing a situation where if I lost, I was bankrupt. It was as straightforward as that.
And when you said there were some perverse outcomes from libel actions you've heard before, is there any details of those? Because we've heard on separate other occasions from evidence and said, look, no, there hasn't been.
Yeah. So the most celebrated stroke infamous of these is the Goodfellas pizza case. It's now probably close to 2 decades ago. It was a restaurant review in the Irish News, which said that the restaurant reviewer didn't really like the establishment that they were reviewing, and the High Court in Belfast found that this was defamatory. There was a huge sum facing the Irish News. It was a threat to restaurant reviews across the entire UK, to the extent that the Times sent their restaurant critic to Northern Ireland to do a review of the restaurant, and it wasn't very flattering. To make the point that restaurant reviews have to be subjective. That's the whole point. If somebody reviews my book and says that they think it's trash, that has to be a freedom that they have. They can't feel a fear that they have to somehow justify why they feel that way about it. So that was the most egregious example. But really, I was in a situation where, as you can imagine, there was a pretty uncomfortable conversation with my wife, because what I was deciding to do in pressing ahead with publishing the book in an unamended form was not just going to have implications for me, it was going to have implications for her, for our young children, for the house that we live in. That is not a situation that an investigative journalist doing due diligence, asking people about whom they are writing reasonable questions in the public interest should face. There is no justification for that, and yet it is routine in my experience that is how certain individuals, and I should make clear that there are lots of people in the DUP and in other parties who do not behave like this, but there are some people who repeatedly behave in this way. I will skip the third case unless you want me to come back to it for reasons of brevity.
Sorry. No, sir, we're a bit time compressed, but we might pick up on it on questions afterwards.
Sure. And just finally, I think it's important. It's important, as I said at the outset, that most media, and David obviously represents non-commercial media here, the BBC is effectively a public sector organisation or a quasi-public sector organisation, but that is the exception in the UK and Ireland. We're overwhelmingly a jurisdiction in which newspapers or websites or media organisations are commercial businesses, and there is a very clear chilling effect on us being able to do our jobs. You people know who I am. You know what I write. It's in the paper under my byline. I don't troll people online under anonymous accounts. I don't rifle through your bins. I don't try to see if you've been having affairs, and I'm not going to look at anybody because I'm not referring to anybody on this committee. That's not the sort of journalism I do. And yet I could paper my walls with these letters, and it is very well for somebody like Mr. Tweed to say, look, it's not a big problem. I really don't think somebody should be intimidated by a letter that says that they might be sued, that they might face hundreds of thousands of pounds of damages, etc., for really innocuous questions. But it's not easy when you're in my position. Thank you very much.
That's a chilling effect. Thanks very much indeed. David?
Sorry, he's still muted. Sorry,
David, can you unmute yourself?
No, I think we've muted him. Hold on, just bear with us. Okay, go.
Go ahead, David.
Thank you, Mr. Chairman. Thank you. I'm very grateful for the opportunity for the BBC to make representations and for me to appear before you today. The BBC strongly supports the Defamation Bill, which, for the reasons Sam McBride has outlined, will, we think, bolster public interest journalism in an important way. But more fundamentally, I believe it will result in other benefits which will affect both claimants, plaintiffs and defendants. And this is because it will lead to, contrary to what Mr. Tweed has said, I think it will lead to quicker and more efficient determination of libel claims. The cheapest libel action is one that settles early, and the retention of jury trials in Northern Ireland is a big impediment to the settlement of claims. And this is because the single most important element of an action which will determine whether it succeeds or fails is only determined during the trial itself. In England and Wales, the abolition of the presumption of jury trials, I think, has had overwhelmingly positive effects in that it's fundamentally changed the way libel and defamation is conducted. In most cases now, there'll be an early determination of meaning, and we've had at the BBC 2 recent experiences of this. In both those cases, the determinations actually went against the BBC, but we knew early that we were defending an article that we had not intended in reality to publish. We had allegations that we had not in reality intended to publish, and of course that made us realise, is this something that we wish to commit to defend, or should we seek a settlement? And if you look at the published judgments which are available on Bailey and on various resources, you'll see a large number of court decisions now focusing on meaning. And I think if you look down the line, you won't find any further judgment in a lot of those cases, because actually that's the determination of that single issue prompts settlement. One of the difficulties we face, and I think Mr. McBride has already alluded to it, is there really is no jeopardy, there really is no risk in a plaintiff putting forward exaggerated meanings at the start of the claim. That doesn't get rumbled in Northern Ireland. The case can proceed all the way to trial with a very serious meaning hanging over the defendant, which the defendant doesn't believe it intended to convey, which the defendant doesn't believe the article in fact conveyed, but still with the risk that a jury may disagree with that. And there's no mechanism, there's no effective mechanism for having that thrashed out early. I think very, very fundamentally, it will allow claims to be resolved quickly. Quicker is cheaper, and it also means court resources are much better used. The typical determination of meaning will be dealt with in 2 hours or half a day. So I think whilst not widely heralded, that's a very insignificant consequence of Clause 11. I'd also highlight that the importance of there being a unified body of law. Northern Ireland would be an outlier if this legislation does not pass. Reputation, protection of reputation is not just dealt with by defamation. It's dealt with through the laws of privacy, through data protection, through protection of harassment, potentially also indirectly through online harms. All those matters are legislation which applies across the United Kingdom, or there's a body of case law which applies across the United Kingdom. And defamation would be an outlier, and that would be a sort of an artificial situation where reputation claims which are sort of intended to protect the reputation or restore the reputation of an individual, often don't just rely on defamation. They often bring into play privacy, they often bring into play data protection. You'll have a sliver of the case.
David, just to cut across there. Obviously, with the BBC being across the whole of our nation, but one of the issues we've heard evidence on is issues with Scotland, and Scotland has a different approach. Now, we understand the difference in the Scottish legal system, but could you just quickly outline those? Because I think that's quite an important point you brought out, that Northern Ireland shouldn't be an outlier, particularly for sort of defamation law across our nation. But could you just sort of touch on that Scottish issue, if you could, for a second?
So I'm not a Scottish lawyer, but Scotland has recently passed, I think it's called the Malicious Information and Defamation Act, which has received royal assent. So it's on the statute books. I don't believe it is enforced, but it will bring into play.
We've lost you.
Interest events. Sorry, so in Scotland, on the statute books, I'm not sure if it is yet enforced. There is a new Scottish Act, I think it's called the Malicious Communication and Defamation Act. That introduces a serious harm test. That introduces a statutory public interest defence, very similar to Clause 4. That introduces, very importantly, because I think it is a significant difference, and it's a difference which is going to increase as time progresses, single publication rule. And I know Mr. Tweed was challenging as to whether libel tourism exists, and I think it's sort of difficult to prove, but I think there are certainly cases which are being brought in Northern Ireland which would not now be brought or could not now be brought in England. And certainly there's one case which we are currently dealing with, where the online publication occurred more than a year ago. That would be statute barred in England. That would be statute barred if Clause 8 comes into effect. But that is a libel action that is currently proceeding in Northern Ireland. And that is a sort of an example of the outlier that I have in mind. But I think even more importantly is it's very hard to see if Northern Ireland continues with a jurisdiction where whether an article is defamatory or not is tested according to Jamil, a Supreme Court decision from 2013, or whether a public interest defence applies is determined by the Reynolds case from, I think, 1999. It's very hard to see how that law does not become ossified, because in the absence of judge trials, you do not get reasoned decisions. So there will be no further decisions as to what is the trigger, what is the degree of impact that a libel needs to have for it to be actionable. How does the public interest defence evolve with new technologies or new standards or differing strategies? It's very hard to see where that body of law is going to come from. It's and I fear that we will be advising and litigating very much in a vacuum, with a body of legislation increasingly disappearing in the rearview mirror, or body of case law, which is increasingly disappearing in the rearview mirror.
So just to touch base on that again, because obviously with case law being developed and cases going through this, getting as far as the Supreme Court, then creates the necessary precedent, because we are detached from that. So what you're saying is basically we're stuck behind, and progressively as the rest of the nations move on, we're getting further and further behind.
Yes, well, any public interest defence moving forwards, whether it's Scotland or England, is going to proceed on a very similar basis to Clause 4. It's not going to proceed on the basis of Reynolds, which has been expressly disapplied in England. Yet, in Northern Ireland, the most important authority is still an authority from the previous century on the public interest defence. And I don't see how, given that England and Scotland will have court decisions based on a different legislative test, I don't see how a new body of law can possibly evolve now in Northern Ireland. So you'll be increasingly, as I say, looking at a piece of looking at a case law which is disappearing fast in the rearview mirror.
Okay.
I'll highlight as well, I mentioned that we are currently dealing with a case which I think in England could not be brought because it would be time barred. I think the single publication rule is not one which I think Mr. Tweed or Sam McBride alluded to. I think it is very significant. I think there is a real chilling effect. The availability of newspaper archives, I think, does serve a significant public good. I think there's a very strong public interest in having a tight limitation period. For many years now, that has been 1 year. In Northern Ireland, there exists an exception to that with regard to online publications, because the continuing existence of the online publication is seen as extending that indefinitely. So in Northern Ireland, we do have what I consider a significant outlier, which is going to increase as the internet becomes a bigger and bigger store of archive information, whereby a claim can be brought many years after publication, at a time when important witnesses may not be contactable, a time when memory has faded, where documents may no longer be accessible or have been kept. And I think that is a significant risk where, forum shopping I don't think exists as a significant problem, but I think the extended limitation period in Northern Ireland is an example where...
Just so I get this right, the current limitation period in the rest of our nation is 1 year. In Northern Ireland...
It is in Northern Ireland. It is in Northern Ireland 1 year.
Yeah.
But how that 1 year is calculated for online publications is different in Northern Ireland.
Could you explain that?
Yes. So in England, the 1 year period starts when the publication first appears on the BBC's website.
Yeah.
So after 1 year of the article being available online, the limitation period ends and it can no longer be litigated over.
Right, okay, got it. Yep.
In Northern Ireland, the continued existence of the article online is considered to be a new publication. So if the article was published a year ago but is available today, you still have 1 year. So in effect, for an online publication in Northern Ireland, the limitation period is never ending, essentially.
So
it's
basically, if I access something off whatever particular web system, that would deem to be the start of 1 year? All right?
Yes.
Yep.
Okay. Thanks.
That is right, and that's an outlier which the 2013 Defamation Act in England corrected, which the Scottish legislation has corrected. I would say still exists in Northern Ireland, and we are currently facing a claim has been issued, and we are defending, which under the 1 year period in England could not have been brought.
Okay. Yeah. Thanks.
And I'll very briefly touch on Section 5 because I know Mr. Tweed, and I think it is a fair point that this bill does not address all the ills in the world of publishing, particularly online publishing. Far from it. But I do have a difficulty with his position on Section 5, the operators of websites. Section 5 is a start. At the moment, I know Mr. Tweed says he doesn't accept the legal position, but I think most lawyers would say at the moment there is very little jeopardy because of the e-commerce directive and because of US legislation. There is very little jeopardy that online publishers have. So Section 5 is actually a start in trying to hold online publishers accountable for the content. And it does provide a mechanism, maybe convoluted, and maybe amendments can be made to the bill or to the regulations underneath the bill, which, learning from the English experience, can be better and more streamlined and more effective. But it is better than nothing. It is a start. It is a process by which someone can try and get justice out of Facebook. And I can't see the objection that it doesn't cure all the ills. It is, I think, a step in the right direction. It provides a process. And serious harm as well, I would say, is I do feel it is important. It's one of those areas where I don't like the claim that there is forum shopping going on to any significant degree. And I hear Paul Tweed argues very well that we'll point to the cases. But what I do feel is we face threats in Northern Ireland, and we sometimes face cases in Northern Ireland, which we feel could probably be disposed of quickly in England because of the serious harm test. And I would ask whether it really does offend against a sense of justice, to have a serious harm test. Before I focused on pre-publication advice, I spent many years in litigation, and you do tear your hair out at the sorts of cases where, to use an analogy, they are the neighbours in dispute over a hedge. And you do feel there needs to be a proportionality here. These are high court claims potentially involving jurors who are giving up their time to hear a dispute. Out of respect to the jurors, there needs to be a threshold, a sensible threshold, at which this becomes a matter which the High Court should be seized, in which jurors should be expected or feel they have a duty and a responsibility to preside over. There has been litigation, satellite litigation, over the serious harm issue, like there has been over the Section 4 issue. And Mr. Tweed very eloquently points to the costs that have been incurred. But I would say coming in at this stage, you get the benefit of the heavy lifting which has been done by the Supreme Court. We now have very clear Supreme Court decisions which pinpoint what is meant by serious harm. We have a very clear Supreme Court decision which I would say really pinpoints how you assess the Section 4 public interest test. So if those clauses were adopted and passed, that satellite litigation, that is, that's a learning experience which English litigants have had to bear, and I think you would there would be a body of much clearer law which would be inherited.
Okay. Thank you very much indeed.
Those are the main points I wish to make, and I hope they were helpful.
Okay, thanks very much indeed. I'm just going to open I'll ask a few questions as we've gone along, but I'll just open up the floor to question. Matthew, you're first up.
Thank you, Chair, and thank you both Sam and David, for your really comprehensive evidence. I'm trying to take too much. I will just comment before I come on to your questions. It was quite striking that Mr. Tweed seemed to be suggesting that one of the flaws in this bill was that we weren't taking Google, Facebook and Twitter down a peg or two. That would be great, but obviously, you know, if the US Congress and the European Commission are having a hard time, then the Northern Ireland, the humble little Northern Ireland Assembly is probably, you know, perhaps not probably we're not to be found at fault because we're not introducing comprehensive regulation of social media in the next 4 or 5 months. I'm not sure that's a reasonable complaint. Anyway, Sam, you talked about those examples where there has been a chilling effect. Is it can you give an example of how, have you seen a differential between how that works? So, for example, the newsletter is owned by Johnson, who were obviously a UK-wide publisher. Your current employers is now owned by I don't know, the Belgian or Continental on there, but obviously the group is it's an Ireland-wide group. So both of those publishers had kind of experiences in different jurisdictions. Did you get a sense from the management that this jurisdiction in Northern Ireland was specifically more litigious or favourable to litigants?
Yes, more than a sense of it. There was a rule instigated by Johnston Press that Northern Ireland publication in relation to certain individuals had to go through certain hoops that a equivalent publication at the Scotsman or the Yorkshire Post or the News in Portsmouth or any of their other papers in Great Britain did not have to go through. It made it more difficult. If you're somebody as a journalist who is quite determined to get something in, I'm not saying that you can't always get it in, but it's harder. It makes it more difficult, and it is a hurdle which quite literally does not exist within that major UK publisher. I don't know what the situation is now. I'm not there. They're under new ownership. But certainly for several years, that was the situation. And I was struck when I was reading David's written evidence last night, which the committee had sent to me, that even in the BBC, which is obviously the biggest media organisation in these islands, it's one of the biggest media organisations in the world. They're dealing with wealthy financiers in the City of London. They're dealing with dictators who they're reporting on from around the world. They're dealing with dodgy businessmen. They've got all sorts of people who might be thought to be litigious. And he's saying that they have this particular problem in Little Northern Ireland. I think that says an awful lot, that it's not just about people thinking they can take on what they might perceive to be medium-sized regional newspapers. They're so confident they'll even take on the BBC in these terms.
David, could you say, thank you, Sam. David, could you say something about that? As Sam said, you are a global media organisation who are, you know, often up against not just irate DUP politicians, but dictators. And what's particular about this jurisdiction, and is it something that BBC are aware of at a corporate level?
Yes, we are aware of it at a corporate level, I think. It's very, I sort of hesitated when I wrote the submission whether to use the phrase disproportionate or not, because I'm very mindful that BBC Northern Ireland produces some pretty punchy current affairs and some very sort of high value investigative journalism comes out of BBC Belfast, Spotlight and Stephen Nolan being two obvious examples. So it punches above its weight, so you may expect there to be a disproportionate number of libel complaints and defamation actions that flow from that. So it's very hard to see whether it's truly disproportionate, but my sense is it probably is. The numbers are small in absolute terms, but I would guess, and I was sort of reviewing the figures last night, that around 20% of serious complaints and claims emanate from Northern Ireland. From a single jurisdiction.
Sorry, David.
And that feels, to me,
could I have
quite significant.
Yeah, David, sorry, I think that was an important statistic. Did you say 20% of serious, is that 20% of serious libel claims that the BBC faces are from Northern Ireland?
I would say 20%. The numbers are small in absolute terms. You know, the numbers are single figures for claims issued each year. Across the years, and I've looked back over the last 10 years, my estimate is, you look at sort of serious complaints and issued claims together, I would say 20%. have emanated from Northern Ireland.
So just so I'm clear, that when you say clear, is that where a writ has been issued, or is that simply where there's been a...
No, because often a writ isn't issued, and they'll be resolved without the issue of a writ. The numbers are probably too small where writs are issued, to be honest. We have handfuls of issued writs each year, so it's very difficult with the law of small numbers, I think, to try and put a percentage figure on it. But
Sorry,
20 across the last 10 years, 20% would be my estimate of where I'd say serious threats have been made or where claims have been
2 or
issued.
3% of the population.
The difficulty with claims have been issued. If we have 3 or 4 claims issued in a year and one is from Northern Ireland, is that, or 2 are from Northern Ireland, potentially that may be 50%. I'm sure I can find a year where 50% of the claims have been issued in Northern Ireland because we only had 4 claims. It's very difficult with such numbers.
David, to cut across there, because I think this is a particularly important point, because we've heard evidence as we've gone through that this isn't necessarily having a chilling effect. But if you were saying that the BBC, which is one of the world's largest global broadcasting organisations, and with all your online activity and all the rest of it, and 20% of the activity that you have a concern is about from Northern Ireland, bearing in mind all the other sort of activity that there is there, and you're a senior legal advisor within the BBC, that alone would probably say that somewhere in the BBC's risk register there's an issue that if anything's to do with Northern Ireland, it puts a flag up. I hate using the term in Northern Ireland, using a flag, but you know what I mean.
It puts a flag up for a number of reasons, and I don't want to exaggerate the chilling effect. We are fortunate to have resource and expertise and good journalists. So I wouldn't necessarily endorse. I don't think a major investigation we have had to collapse in Northern Ireland, which we would have pursued in England. I don't think I can give a clear example of that. It's much more on the margins of having to deal with complaints which we may take a different view on in Northern Ireland because we haven't got the serious harm threshold, or because we can't see a simple means of expediting the claim so it could be resolved at an early stage cost effectively. You're in for a long slog, I would say, often in Northern Ireland because of the back process for resolving claims. So I think on the margins, it does colour how we view complaints, and I think on the margins, it does colour how we advise on programmes because of the lack of serious harm test. If we get a complaint about an online publication, inevitably we are cognizant of the longer tail of actionability that exists in Northern Ireland. We just have to.
Okay, that's helpful. And obviously, as you've acknowledged, David, the very fact of the chilling effect. If the BBC, the biggest, most powerful media organisation in these islands and one of them in the world, is being chilled, then that would be. But even if at the margins it's having an influence,
it colours. It has an influence. Okay. As I say, I can't point to a high public interest investigation which has collapsed simply because of Northern Irish laws. We're not in that terrain, to be fair.
Well, I can relate to an example not that long ago, and I won't name the journalist or the media company involved, but where a journalist said to me that they had been effectively told to
drop it.
Kind of,
yeah,
pretty much.
No, I absolutely believe that as well.
It was present company accepted because it wasn't Mr. McBride. But can I ask Sam McBride one more question? You mentioned that there was as it were, tell me if I'm putting this wrong, a list of politicians. No, I don't. Were they all DUP people? I don't want to be particular about it. But were there? So this was a list of politicians. Was it, or was it just politicians, or was it?
No, it wasn't. Figures? It was people who were known to be litigious in this area. I think that it is true that in my time as a journalist, the DUP are the most litigious party when it comes to this area. However, I should make clear that Mr. Buchanan has never sent us any complaints in this area. Most, I don't think Mr. Wells has, certainly when he was in the DUP. So it is actually a relatively, in absolute terms, it's a relatively small number of people, but very powerful people, and people who know that it works. They've been doing it for years. And I think one other thing that I would like to clarify, just picking up on something that David said there, in the evidence session several weeks ago from the departmental officials, they made the point that the number of cases since, and I'm speaking here slightly off the top of my head, but if I recall correctly, they made the point that the number of cases since the 2013 Act not being implemented in Northern Ireland had gone down. Ergo, there's no problem here. It's no big deal, effectively, and I'm of course not quoting them verbatim there. I think the opposite is the case. In my experience, the vast majority of these cases don't go anywhere near court. Yeah. That's not really the issue. In fact, in some ways, that is the issue. The evidence, yeah. And so, in my time, I've probably seen something like 30 or 40 solicitors' letters threatening legal action. Most of them in relation to politicians. That's perhaps because I was political editor for most of that time. But there is only one case I've been involved in which has ever entered court, and that case didn't go to trial, and it cost hundreds of thousands of pounds without even going to trial before it was settled. So just to give you a sense that it's not about whether you lose at trial, it's about the fact that you don't think you can even get to trial, and that is the problem.
I'll leave it at that, Chair, but I think there's a very strong argument that our law, whether we update our law or not, that increasingly these laws are never tested in court because media titles are scared to. Anyway.
Just before I bring in the next one, Sam, we were talking about that, but you're also talking about the issue with the book. But the book was also published in Dublin, so there was no attempt in Dublin. It was decided to do it specifically in Northern Ireland rather than in Dublin, or was it published separately in?
Well, it was printed, I suppose. I think printers, David will know more about this than me. I think printers have an exemption from this, and newsagents and booksellers, etc. But it never got to the stage of a writ, so it wasn't about, I suppose, picking a jurisdiction in which to sue over it. But the fact that it was, in my view, simply an attempt to bully probably my publisher more than me. I think they knew that I wasn't going to be bullied about it, but they thought, tell your publisher about this. It's a relatively small company outside Dublin, and they were, I think, the fact that there was no legitimate concern about the book, I think, is evident from the fact that there wasn't a comma of the book that was challenged after it was published. I mean, it was 150,000 words, but it was an attempt to stop it ever getting there.
But even though the publisher was in the Irish Republic, it was aimed here.
Well, I think that was, I mean, it was a solicitor in Northern Ireland acting for the DUP. I think that is because the DUP are in Northern Ireland. I don't think they got to the stage of choosing that they would issue a writ.
Sorry, Militia. Sorry.
Okay, thank you, Chair. Agus fáilte ófalig, you're both very welcome, Sam and David. Sam, if I come to you first on this one, just and check me if I'm actually wrong, and this is your own sort of submission. I hold no brief for liars, but if lies are not causing serious harm, should we not prioritise free speech? Yeah. Now, I find that an astonishing statement. That you're saying it's okay to lie, but someone, as long as it doesn't cause them serious harm in the eyes of the court, that it's okay. Is that a fair assessment?
No, I'm certainly not saying that in an ethical way, in a moral way, it's okay to lie. I believe it's utterly unacceptable, it's reprehensible, it should be frowned upon, those people should be ostracised if they're known to be liars. But should it be litigated? Should we go to court over everybody that tells a lie? Absolutely not. I mean, the courts would be filled. We'd have millions of cases every year. So I don't think it's a controversial statement to say that simply because somebody tells a lie, that we should go to the High Court and spend hundreds of thousands of pounds to litigate that.
But I don't think that the intention there actually is that it is for an individual tells a lie, but when it's printed or reproduced in the media and the likes of it as a lie, is that not cause for serious concern?
Well, if there is a lie that is printed that is demonstrably untrue, there will be nothing in this bill that stops somebody, if that has had a significant impact on them, from taking a libel action. That is clearly still going on in England and Wales. There have been lots of very high-profile libel actions there since the 2013 Act, to the extent that Paul Tweed says that he doesn't really think this helps the media at all. So, I mean, I don't think we can really have it both ways by saying that actually actually the 2013 Act is something that doesn't help the media. It makes it more problematic for them, makes it more costly. But on the other hand, this would be disastrous and would open the floodgates. And when the 2013 Act was going through the Houses of Parliament, Paul Tweed was quoted by Ian Paisley Jr., who is well known to be one of his clients, who said that Paul Tweed had told him that it was, and I've just lost this here, but he basically said that there was a situation where if you weren't an axe murderer, I think was the phrase that he used, you really would have very little hope with a libel action. I think it's clear that's not the case, and I entirely accept what Paul Tweed says about libel tourism. I don't see any great evidence that it's happened in Northern Ireland, but I think that we should be careful about deducing from that couldn't happen in Northern Ireland, particularly the longer that these two jurisdictions diverge. So if you are, in absolute terms, in Northern Ireland, more likely to succeed in a libel action, and for sake of argument, you're Boris Johnson, you're a public figure in both jurisdictions, why wouldn't you take it in Northern Ireland?
Well, sorry, I'm not here to defend Paul Tweed, but that he didn't say that there wasn't any great evidence. He said there was no evidence at all of there being sort of tourist libelism in the north of Ireland. But to get back to the same point again, in terms of, let's say, that lie and whether or not it causes serious harm. And David, if I could direct this one to you, because you commented there that there has been a decision, say, within the High Court and so on, in relation to serious harm, where they were very definitive about it. Now, Paul Tweed in particular had no confusion that it's not defined, i.e. serious harm. And is it not a subjective term in the very first instance? Who is it that actually arrives at that conclusion in terms of serious harm?
It is, I suppose, inevitably subjective to a degree, but what we now have is a Supreme Court decision, a case called Le Show, which was brought against the Evening Standard and the Independent newspaper, which went through the High Court and the Court of Appeal and ultimately the Supreme Court on this test of what serious harm means. And I think we know what emerges from it is something that is, you need to show that something demonstrable has flowed from it, and it needs to have some impact. It doesn't have to be devastating, but it needs to have some impact. And the impact, of course, you take in context. So I think Mr. Tweed gave an example of, well, if it sort of causes tensions within a family, if my children no longer speak to me because they believe something they've read about me or seen online about me, that, of course, would be serious harm. The damage of one or two relationships can be serious harm if they are relationships that matter. If you don't have Section 1, you still have the Supreme Court decision of Jamil, which would be what the Northern Irish courts would apply. That is still a subjective test. It's arguably slightly lower, or it is slightly lower. But what it isn't anything which is going to evolve. There's going to be no more cases, or very few cases, which will enhance the understanding of that. So I use the phrase that there'll be a body of law which is increasingly receding in the rearview mirror. There'll be an early 2000 Supreme Court decision of Jamil where the pre-2013 requirement for harm was really looked at. It's very hard to see that is as subjective. If there's a criticism of Section 1 is subjective, then it applies equally to that. The benefit of Section 1 is we have recent Supreme Court authority on the point, and if there's further clarification needed in due course, that undoubtedly will come from the decided cases.
And just finally, just through the chair, if I could also suggest that, and I'm not suggesting that either you, David, or you, Sam, are in any way benefiting from this, but that Clause 1 in itself, is it about protecting rich and powerful elements of the media or the big companies in terms of social media and all the rest of it, as opposed to defending the right of the individual? Well,
it's... Can I take that? I don't think so, because one of the... I think 2 points. Serious harm is all about impact. The BBC has more impact than a community newspaper has. So we're already one step back in defending a serious harm case because of our reach and because of the gravitas of our publication. So, serious harm is probably of most benefit to the community newsletter type of publication rather than to the BBC. Secondly, for organisations like the BBC, and I absolutely take the point about we can't have a licence to lie, but most of the media is regulated. Most of the media has Ofcom or WIPSO or a press regulator, which will come down pretty hard if untruths are published and will force corrections to be published and will provide vindication. So defamation is not the only route through which reputations and inaccuracies can be dealt with. So I would say that serious harm much more important, much more beneficial for someone writing a community newsletter than for the BBC.
Can I just add to that, that it also, I think, redresses the balance here in striking out at an early stage this sort of Gregory Campbell complaint that I have given you the details of. There is no way that he could say that that caused him serious harm. There's no way that somebody, crossed the street to get away from him the next week after they read that about him. He was incidental to the story. He wasn't in the headline. He wasn't in the image. He was mentioned in 14 words, etc., etc. And what was said about him was really incredibly anodyne, frankly, in the context of what some people have said about him, and so therefore there would be no way that he could do what he did in sending a solicitor's letter without knowing that he's going to end up paying the full bill for that. And if you engage a solicitor, there's a lot of costs involved, so it's not entirely risk-free if you think you might have to pay for it. But of course, if you think that you're never going to have to pay for it, why wouldn't you?
Well, just if I can comment on that too, that I don't really think that it ever is a deterrent in itself whenever they would receive the solicitor's letter, even to the extent of where I don't know what you would call him, a researcher or whatever, who works to a particular radio station, actually had himself on social media saying, this is what we do with solicitors' letters that come into us, and he sat there tearing them up and throwing them into a dustbin. So quite clearly, they weren't having that impact of actually limiting what it was that they were doing, either as broadcasters or whatever.
I think that was how that particular complaint, which I think it's probably important to say was a complaint from you or from your solicitor, wasn't it? Isn't that correct?
The complaint was not about him tearing up a letter from me or from my solicitor, no.
Okay.
It was him sort of talking about how he deals with complaints going into
Well, it was David Thompson and the Nolan show, I think. It was Stephen Nolan, and you had sent a complaint to them. I mean, I think just because these don't...
Just one thing here, Chair. I'm giving, because this is a very important piece of legislation that we're looking to as well, and we do have privilege, but let's just be a degree of caution, please. I'm not going to stymie any debate, because I think this is vitally important. I think we've learnt a lot in what we're doing, but just please let's have a degree of caution.
I was just trying to make sure I didn't misunderstand.
So it had nothing to do with my case or anything else per se.
Okay.
It could have been any case. I'm just making that observation. So to what extent does it really hinder either the BBC or, in fact, newspapers from...
Well, I think what I have shown is that it does hinder newspapers. I've given clear examples of that. The fact that it doesn't always hinder newspapers, or that some people have thicker skins than others, some people are prepared to take risks that other people aren't prepared to take, doesn't show there isn't a problem. It shows that there is a problem, and those people are prepared to take an element of risk in doing that. Not everyone will be or should be having to take those decisions.
Yeah. But sorry, I started talking about Malaysia, but I mean, I think we've heard from the BBC at one end of the spectrum to sort of small newspapers in Northern Ireland at the other end of the spectrum, all feel this effect. I think would be safe to surmise between the two of you. Okay, thanks.
Thank you, Chair.
Cheers, thanks. Jim? Jim Alister.
Jim. Gentlemen, I don't think I do either of you a disservice if I characterise you and your evidence as being in the interest of likely defendants in libel cases.
Yep.
So clearly you see this bill as an aid for defendants.
Yes.
Now, on the point, Sam, that you're polluted with speculative, extravagant solicitors' letters of a threatening and bullying nature, how would this bill diminish the writing of threatening and bullying letters?
So, When Paul Tweed says that it wouldn't stop it, he's of course correct. Within the bounds of what a solicitor is allowed to do by their professional bodies, they can send whatever they like. However, there is cost involved in this. Paul Tweed doesn't, I'm using him as an example because he was here before me, but Solicitor A, who sends libel letters to journalists, doesn't really care about it. I mean, they're doing it as a professional act. They're making money out of it. They've got a business, whatever, of course. But it doesn't mean anything to them. The person who's paying the bill, ultimately, if it doesn't go anywhere, is the person who is employing them, the client. And so if the client thinks that actually there is more in the armoury of the defendant, in this case the publisher, I don't think you're likely to get as many. You're not going to eliminate it, but you're not going to get as many of these, frankly, vexatious claims, but claims which in Northern Ireland, unfortunately, can't be dealt with in the way that a vexatious claim in the rest of the UK would be dealt with.
That's because you believe that serious harm gives you a shield and prevents and discourages the writing of threatening letters.
Yes. It raises
Which
the bar
brings
somewhat.
me back, raises the bar, which brings me back to the sentence that Mr McHugh drew your attention to. I thought when I read it you were being facetious, but it seems not. When you wrote that, but if lies are not causing serious harm, should we not prioritise free speech? You weren't being facetious?
No.
You were deadly serious?
But I think that, I mean, you can characterise this in different ways, but I think that if you think about it like this, if I say that you are wearing a white suit, it's a lie. You're not wearing a white suit, but it's not something that causes you any harm, and I think we could all agree we shouldn't be going to the law about that, unless with some particular reason.
Who would ever go to the law on that on our present legislation?
No, but you could try. I mean, I'm giving an extreme example of something. Of course, that's not what we're dealing with here. But I think what I'm trying to say is that lies in themselves should not necessarily be actionable. I mean,
so what you want is immunity for publishers to tell lies that don't cause serious harm.
It's not immunity because what
else is it?
Well, there is, as David has said, already a bar to get over. So we already accept that you can't simply go to the law over anything. What we're arguing here about is not whether lies should be illegal, if you like, or at least actionable in a civil way. What we're arguing about is which lies, how far up the ladder.
Which lies?
Exactly.
In other words, immunity for lies that don't cause serious harm.
Yes.
So it's okay to lie, provided the law will rule that you didn't cause serious harm.
So it's not.
That's a charter to lie.
No. So first of all, we are viewing this in isolation. We're looking at this in terms of defamation law because that's what is before you as a bill. Newspapers don't operate in isolation. Newspapers which routinely lie have got no readership because they're known to be liars. That's not a credible position. If the BBC routinely has to correct their output because they are lying about somebody or they're saying something which can demonstrably be demonstrated in newspapers or in social media or in other ways to be lies, that's not a situation any journalist or media organisation wants to be in. It's not good commercially. It's not good ethically. It's not what any of us got into the business to do. So therefore, this is about whether those lies should go to court. It's not about whether it's okay or not.
Strip away the verbiage. What you're advocating is that a publisher should be able to publish a lie with immunity,
no,
provided
with immunity.
Provided it doesn't cause serious harm.
No, because
some wigged and gowned judge will decide whether or not it is serious harm.
No, because there is not immunity in other areas. So there has already been reference to IPSO, which I can tell you is something which is absolutely taken seriously by the media. They can order us to print a front page retraction. That is not something any newspaper editor wants on their watch. That's not immunity. If there's a lie, this is not. I think the mistake here is that in Northern Ireland, and particularly some politicians, have viewed defamation as the immediate first stage. So it's not a case of let's phone up, Sam McBride and say, actually, you know what, I'm not a terrorist. Can you make that clear? Or whatever else it might be. Go to IPSO, go to something else. It's immediately, how much money are you going to give me for that? That's what we're talking about here. That's the reality.
Well, I understand there are greedy people in all walks of life, politicians as well, but I'm more interested in the less powerful, the guy who doesn't have recourse to a political party or the lawyers of a political party, but who has been lied about and feels that now, because there's no legal aid, it is beyond their reach to do anything about it, and you want to put it beyond their reach.
So, I think that it is true that libel law will very rarely help the man or woman in the street. That is the reality. It has been the reality for hundreds of years, when the laws were very tight, when the laws were slightly looser as they are now, and if this was to change. No. I think that it is clear that this is a form of law that is open to the wealthy, to the powerful. It's used by them. There are other avenues. I've referred to IPSO. IPSO is an entirely free process.
Should there be any libel law?
Sorry?
Should there be any
Oh,
defamation?
absolutely. I mean, I have said publicly, and it was one of the reasons why I was so surprised at what Paul Tweed had said about the Christian Jessen case, that is exactly the sort of case which should be held to be defamatory. He acted in an appalling way, a reprehensible way, and of course he should be held to account for that and be hit in his pocket for that. But so I do not want to see a situation like in America where you can almost say what you like about somebody. Of course not. We're talking here about modest changes. That is not the situation that pertains with the Times in London, with the Daily Telegraph, the Guardian. That's not. They're not in a free-for-all right now.
I disagree that it's a modest change to require a non-funded plaintiff who has been lied about to have to cross a threshold of serious harm before he can do anything about it. And if he fails at that, he's in a worse position because he's run up his own costs and your costs, so as you have the privilege, you the publishers, of telling lies about him.
No, I think this is founded on the misapprehension that at the moment, or even if this bill was to pass or whatever legislation there was, that libel law is ever in reality available to somebody who's a plumber or a builder. It just doesn't happen. I have received lots of these letters. They always come from powerful people. That is the reality.
Is that because the letters from the plumber or the builder you can afford to throw in the bin?
No, we just don't get them.
That they haven't got the wherewithal to come after you.
Not at all.
Go ahead.
Sorry.
Come on, David.
I mean, I'd like just to sort of add my response to this. The mainstream press, the mainstream broadcasters are heavily regulated with obligations of accuracy and swift, free, effective mechanisms to redress that. We get 100 complaints from the plumbers and the builders, which our internal processes deal with, which can be appealed to Ofcom and will result in an outcome, including published apologies, free of charge. That is the mechanism overwhelmingly people wish to use. It's quick, it's cheap, it's free, it's effective. Overwhelmingly. It's not free for us because we've got to resource it. We've got to administer it.
Cheap for you.
It's not cheap for us because we've got to resource and investigate. And the BBC complaints process is not a cheap infrastructure.
David, you said
overwhelmingly.
You said something.
Overwhelmingly,
you said something. I just want to make sure I got it correct. Did you say that you had no examples to give us of cases settled in Northern Ireland that wouldn't have been settled in GB?
That's really hard because that's very hard to prove. We certainly have cases which are brought in Northern Ireland which I don't think would be brought in GB in England. We certainly have that. I wouldn't call it. Are there examples
of cases settled in Northern Ireland that wouldn't have been settled in GB?
Very hard because I'm not across every case, I'm not across the legal advice in every case, and I don't know what an English barrister may opine.
So that would
suggest... There are certainly cases which have settled far later. One point of vindication is not like reputation, is not like revenge. Vindication is not a dish best served cold, and mechanisms under the Defamation Bill would allow far speedier processing and access to justice and far speedier resolutions of claims. And I certainly think there are many claims which have run to the door of the court in Northern Ireland because there is no mechanism for banging heads together to resolve issues whilst the jury system is is in process because of the matters which are reserved to the jury. So there's certainly cases where vindication has come late, where costs have been run up. And I suspect there are cases where, I mean, and I keep giving the example of the out-of-time claim, or the claim which would be out of time in England. The serious harm test has only been in for a few years. I think we have had certainly threats. I think we have one issued but potentially, unserved writ in Northern Ireland, which I'd be very surprised if it were issued in England because of the serious harm threshold. But the fact I'm struggling to think of one is, you can argue that both ways. Either there's no problem, or actually the serious harm threshold isn't a significant impediment.
I just want to explore one other thing with you, if I can, because I find your evidence quite confusing on it.
Sorry.
The question of preliminary determination of meaning and the question of preliminary determination of serious harm are freestanding issues. You can have one in legislation without the other. Yes?
It's difficult to see how you can have those in legislation with, I mean, those are both matters reserved to the jury, so it's very difficult to see how you could have a system.
Sorry, in Northern Ireland, as a preliminary issue, you can have a judge rule whether contended meanings are credible.
But it's the test is perversity. The test is extreme. The test is not what the article means.
We had a recent case
on any basis the article could possibly mean. The test is perversity.
We had a recent case where 11 or 12 suggested meanings were thrown out at the preliminary stage. Isn't that correct?
Yes, and I gave you that case as an example. But the judge also commented how much more effective it would be if the meaning could just be determined.
Yes. But is there a halfway house where the question of meaning could be a judicial decision at an early stage, but the question of harm remains a jury question?
I think that is difficult because the jury may just take a different view, and certainly before the 2013 Act, there was a real reluctance for the judiciary to do that, because they considered that ultimately the jury would have to come to its own view, and you can't preempt what that decision would be. So I think it's very hard to see how you determine meaning.
The jury would come to its own view on whether or not there was harm and therefore damages due, but the judge would come to the view as to what meanings would go before the jury.
That's something which hasn't been adopted, is considered not practical because the jury will have their own independent thought on what the article means, and you can't preempt their reaction and their assessment of the article of the publication.
Well, you can, to the extent that what's left to the jury is the meanings determined by the judge.
You can. I mean, this is sort of theoretical because it's never been tried. I think certainly the English courts did not go there. Certainly the Northern Irish courts have not tried to go there. And the test has been where you have a jury, the only thing a judge can determine on meaning is whether a meaning is perverse. Yeah. In other words, it was so off the scale that it shouldn't even be put to the jury for their consideration. It's always been the test of perversity for the very reason that you shouldn't saddle the jury with the judge's thinking. The jury must approach it with an open mind and a clean sheet.
Can you point us to any perverse decisions in Northern Ireland that weren't rectified upon appeal?
No, but it's a small jurisdiction with few cases.
So that might be suggestive that our law isn't so bad after all.
I don't think Northern Irish law is so bad. I think there is an opportunity to align Northern Irish law with English and Scottish law in a way which will ensure strength and uniformity moving forwards. I think the biggest point I've made in my submission is largely around future-proofing Northern Irish law, because there will be a sliver of law. And I know Paul Tweed says, oh, well, the Northern Irish law is different in lots of respects. It is not different in respects where you don't get judges giving reasoned decisions. So there will just be no case law. There will be no case law upon which to determine serious harm, on which to determine...
There would be case law on my scenario, for example, on meanings. There would be case law from Court of Appeal decisions on damages.
Well, there won't be decisions on damages. Those are reserved to the jury.
Yes, on Court of Appeal rulings on damages.
One every 5 years, potentially. I mean, I think there's a real risk of stasis that you have a jurisdiction where considerable responsibility is given to a jury to determine issues without reasoned decisions based on a body of law.
So really, at the end of it, you don't like juries. You don't like juries.
I've sat in two cases with juries present. Two libel trials I've sort of seen go all the way. I had a lot of respect for the jury. I think in both instances they carried out their functions impeccably, and I've got no reason to believe that the jury are going to result in poorer justice than a judge.
So why abolish?
But in both those cases, I got an absolute sense of the jury thinking, well, what am I doing here? I am not trying a serious criminal matter. I'm trying a private issue which frankly doesn't impact me. And also,
but fairly, but trying it fairly.
Judge Fairley, that may be right. My submission is not a jury is going to give an unjust result. That is most definitely not my submission. My submission is you pay a heavy price for a jury, in that you have cases which run and run and run and only settle at trial or only settle on the door of the court because there is no mechanism with the role of the jury intact for narrowing the issues. And my second main submission.
But you equally can pay a heavy price for the determination at the beginning of the case on the question of serious harm, which can take on a life of its own.
I can't, but those are separate matters, and yourselves and your MLA colleagues will need to decide whether serious harm provision is something which you wish to incorporate. I mean, that is in a sense a discrete issue. I feel it is worth incorporating. I feel the benefit it has had in England is positive. I don't feel it's a huge departure in terms of increasing the bar to access to justice. I think it's an effective filter to ensure that claims which actually matter to a degree engage the High Court process. I think there should be a materiality before you can engage the court system, the High Court system.
But haven't we got the filter? Haven't we got the filter of the county court jurisdiction in Northern Ireland?
Yeah, you have, but most. I mean, I would ask Paul Tweed if he ever issues claims in the county court. I'm sure he doesn't.
No, but there are some. There are some for people who don't want to risk a lot of money and who are wanting to establish a principle rather than get a heap of damages. The county court is there for that.
I totally accept. Section 1 is a separate issue, and it will be for the MLAs to decide whether they wish to take on that slightly higher bar with the benefit of uniformity and with the benefit of evolving case law to help guide judges and litigants in the future.
Thank you, Chair.
Chairman, could I make a very brief comment to you, Mr. Allister, something that just came to mind on the idea that this might be a licence for bad behaviour, which I entirely accept is not an unreasonable concern given how we saw some of the media behaved with phone hacking, etc. in London. There is an additional problem for a journalist getting on like that in the current situation. My contract says that I'm bound by the terms of the Society of Editors Code of Conduct, which is pretty rigorous. It's about good journalism, it's about giving people a right of reply, it's about acting ethically, etc., etc. And if I breach that, I'm potentially in breach of my contract. I potentially get sacked. It's gross misconduct.
Mustn't apply to the Sunday World, doesn't it?
I'm not going to comment on other publications, but I mean, speaking from my experience, and I read my contract recently because I signed it recently. It certainly focuses the mind, I think, of somebody who wanted to act unscrupulously there. They would think potentially their job's on the line.
Just a quick one, Sam. Do all journalists have to sign the Society of Editors Code of Conduct, or is it a voluntary code?
So I'm not sure what the situation is in the BBC. If they don't have the code from the Society of Editors, which is largely a newspaper thing, they will have something that's pretty much equivalent, I imagine. But certainly it is, to my knowledge, standard practice across the industry in the UK and Ireland. In the UK and Northern Ireland.
Go ahead, David.
In the BBC, it is a term of the contract of employment that the editorial guidelines are adhered to, and that has got a long chapter on accuracy.
Okay, right, sorry. Jim?
They always say to me, poor Jim Wells, he's stuck on the Violence Committee, it's so dull and boring, and nothing ever happens. Well, I think we can certainly say that that's not the case this afternoon, yet again. But I just want to pick up on one thing you said. You picked out the DUP for criticism as a very interesting line you used, which no doubt will appear in the Belfast Telegraph tomorrow. You said that they used the media as their personal ATM. Nice line. But am I right in thinking that there's other politicians in Northern Ireland who are not DUP have done exactly the same?
Yes. So I think I was cut off, or I cut myself off, or I lost my train of thought earlier when I was speaking about this. There are people in the DUP who do not, as you know, sue newspapers at all. I mean, somebody like I'll not give names, but I mean there are people who pride themselves in rolling with the punches. They dish it out, and they take it, and they view that as an important part of democratic discourse in our country. However, I have noticed, and some of my colleagues in other news organisations in Northern Ireland have noticed, that since the debate about this, about the extension of the 2013 Act to Northern Ireland, Sinn Féin have become much more litigious in this area. They didn't used to almost send us anything. Increasingly, that is almost equal to what we get from certain individuals in the DUP. So this time last year, the newsletter where I was then employed obviously was facing separate libel claims from Arlene Foster as leader of the DUP, who was First Minister, about something I wrote, about something which I was involved in, something which was of very great significance, and from the Deputy First Minister, Michelle O'Neill, actually in relation to something that touches on this committee's work around concerns about an order of PPE and allegations that she had misled the Assembly. Both of those went nowhere. I think that again speaks to the fact that it's not about a genuine claim that can be stood up in court. So if sometimes the media organisation...
So that's happening now. So how, and I think this goes to a previous question, with this bill, that if it goes through, how would that change that?
So I think it redresses the balance. So think about newspaper companies. The Irish News is owned locally. The newsletter is owned by a UK company. The Belfast Telegraph is owned by a company based in Belgium and the Netherlands, I think, ultimately. So it is the exception to have a company like the Irish News or a very small local newspaper that's owned by a family. That is the exception. Generally, these are big conglomerates. And certainly from my experience with Johnston Press, they have lawyers based in London or elsewhere in England. And they are looking at Northern Ireland. And there is a sense, both based on the nature of the claims that they get, the scale of the claims that they get in Northern Ireland, and the fact that a lot of them get very costly very quickly, that this is just a problem jurisdiction. And so there is a related problem here with the point that was being discussed with Mr. Allister earlier about the law ossifying here. So if they think, with their experience, day-to-day in-house lawyers or people who are specialist media lawyers like David, this is something I can be confident about because there was a case in the Court of Appeal in London, or there was a case in the Supreme Court in London recently. It dealt with this. I'm very clear about it. They increasingly over time become less clear about what on earth is going on in Northern Ireland. We're this odd jurisdiction that has got a law that, yes, makes sense to people like Paul Tweed and people in Northern Ireland who know a lot about it, but to somebody who is coming in as a specialist in London, they are more prone, in my experience, to say, look, it's too difficult there. It's Northern Ireland.
Just because I think this is an important point. You're saying at the moment there's basically lawfare.
Yep.
But by changing the law and bringing in this defamation thing, it will, because it changes the balance, it means that will be reduced
Yes, and I mean, look, that's why I said I think this is modest. You know, we can argue about whether it's modest or not, but it's not going to stop it. It never will stop. And frankly, in a democracy, of course, people have to be able to, where they have a genuine concern about their reputation, where they have been libelled. The Christian Jessen case is the ultimate example of this, an outrageous act about one of the most significant aspects of Arlene Foster's character and her conduct. Of course, she has to be able to threaten him and then take action where he responded in the way that he responded, but that's not. I'm trying to get across to you that that is the exception. It's the exception to a rule. And actually, going back to the point about the ordinary person in the street, I think that there's a danger here of having a hypothetical case where the ordinary person in the street might, under the current law, if we keep it and we don't reform it, be able to take a legal action. I'm saying it doesn't happen, but you know. That's for other people to look at the figures and say what their experience is. But I think the reality that we can say, and I can say with absolute clarity does happen, is that the ordinary person in the street doesn't get brought information about their elected representatives, about business people, about senior figures in society, that they have a right to in a democracy. They're losing out right now. And so if you look at this and say that for some hypothetical benefit that I don't think, frankly, is ever going to be achieved for the vast majority of people, you jeopardise this other real benefit that they could have, I think that's a mistake.
Well,
okay, sorry, Jim.
Can I take a bit further? You quoted from your book, which obviously we've all read. I read it over Christmas a few years ago, and sad person that I am. Now, what difference would the legislation that Mr. Nesbitt's proposing, what difference would have that made to what you said in Burned?
So it would have made no difference to what I said in Burned because I took a risk, and as I say, it was a very considerable risk. However, it would make it less likely that somebody would employ a solicitor to send a letter. I mean, employing a solicitor to send a letter like that is not risk-free, it's not cost-free. And if you think it's utterly ludicrous and it's never going to be something that you can stand up in any way, I think what these people are doing is not trying to get an argument that they can win. They're trying to get an argument that they know that the other lawyer says they might just win on a best case scenario in court with a jury, etc., and it would be very costly. That's what they're looking for. And so this just slightly tips a balance. It's not about saying that they couldn't do that. Of course they could, but it makes it less likely.
Okay.
Thank you.
Okay, so Keith.
Okay, thank you, Sam, and I think it's David as well out there. Mr. Tweed referred earlier, Sam, to, and I'm no expert on the media in the United States, about, you read it, probably a large percentage not true. And what you read here, a large percentage is true. Would you agree with that?
In broad terms, I would in sections of the American media, but I mean, I think it's also true to say that there are sections of the American media, the New York Times, the Atlantic, the Washington Post, who have a far more rigorous system of fact-checking, of internal processes to make sure that what they print is accurate than most national newspapers in the UK have. So I think it's a bit of a generalisation. Yes, if you look at one end of the spectrum with the National Enquirer or something like that, yes, absolutely, it's true. But I think that the respected media organs in the United States actually operate to pretty high standards by and large.
So whenever you refer to fact-checking, and you referred earlier, the minute you came through the door earlier, about the Christian Jessen case and Arlene Foster, the picture, etc., which I didn't see the detail on that. What was the fact-checking there?
I'm not sure what your question means. So what fact wasn't checked?
Is the fact-checking in America, or some of those papers you referred to, better than the fact-checking here in Northern Ireland?
Oh, absolutely, because they're massive media organisations making tens of millions of pounds a month, probably, so they can employ thousands of journalists.
Irrespective if you sell 2 newspapers or 100,000, and I appreciate there's a difference of financial scale, is facts not facts?
Yes.
Right. Well, then, whenever I read your thing last night, and appreciate Mr. Allister and Mr. McHugh earlier, I couldn't believe what I was reading, and I'm going to read out for the record. I hold no brief for liars. But if lies are not causing serious harm, should we not prioritise free speech?
Yes.
That would indicate that it's okay to tell lies.
No, I mean, I think that's a very significant misrepresentation of what I've already said orally in this committee.
Sam, with respect, I've read out what you wrote. I didn't write this.
No, but I mean, I've been asked about this. Did I mean that? I've said categorically, no, I didn't mean that. I think it's reprehensible.
Do you realise, and I don't mean just your journalism, with respect to you, do you realise what journalism does in Northern Ireland or anywhere in the United Kingdom, whenever it's wrong?
Sorry, say that again.
Do you realise what incorrect journalism can do to people's lives?
Oh, absolutely, absolutely. And the Christian Jessen case is a great example. I mean, it's not journalism in the sense that it was on social media, but it's a form of media, I suppose, in the modern world.
You know, because we have to get the balance. And I appreciate your point, and I listen to you to be fair. You come in early and you refer to your house and your home and your wife and your children, and I listen to you with intent, and I understand your point of argument, or but we cannot tell lies, and you know, we're politicians. You're a journalist, and you know, we shouldn't be telling lies. But the difficulty is, whenever something goes out there, people catch on it straight away.
So, lest there be any lingering doubt about this whatsoever, I do not think it is a good thing to tell lies. I don't think it's an acceptable thing to tell lies. I don't think it's a moral thing to tell lies. I don't defend people who tell lies.
Are there words that you writ in this?
No. Sorry, if you just let me clarify this, because you've put this to me twice now. The words that I wrote were very clear. What they said is that there is a distinction between saying that something is morally wrong. Lots of things are morally wrong. It's morally wrong for a married man to have an affair. It's not something that he should be brought to court over generally. I think there is a danger in what you're saying in presenting what I have said as somehow defending lies. I've made the very point that I do not defend lies. I oppose lies. I expose them from the Prime Minister down. I've got no problem with that whatsoever. But do we need to go to the High Court over something that is a lie? But it's a minor issue. It's not something that needs to be litigated. And if the very real problem that creates is the current situation where important public interest journalism is being stymied in Northern Ireland, I think that's a reasonable argument to make.
If you were a journalist, Sam, and me not a politician, okay, and you're looking at that law from, I think Masalis referred to the plumber or the electrician, or the Joe public, for example, is that law going to benefit society in Northern Ireland? So take your journalism hat off and take my political hat off.
Yeah.
Is that going to benefit society?
Well, I mean, I should caveat this by saying that I just don't think I can be impartial in this, but I will do my best. And I suppose, setting aside the fact that clearly I've got a vested interest in this, I'm a journalist. I'm quite straightforward about that. I think that most of the media organisations whose evidence I have either heard publicly or seen in the case of David's evidence have been very clear about that. We think this would be good for us. We think it would save us money. We think it would help us get more stories out there, etc., etc. There's no hidden agenda here. That's straightforward. But I think if you're simply looking at whether it's good for me or it's good for Paul Tweed, you're forgetting the person that's most important in this, and that's your constituents. Okay. They're not. That was my question. Yeah. Yes, but as things stand, and as things will stand in this jurisdiction, in Northern Ireland, in the Republic of Ireland, in Great Britain, most people who are of modest means do not have recourse to defamation. It doesn't happen. It is not a reality. It hasn't ever been the case. It is a tool of the powerful. What they do have access to is the media. That's how they understand the world. They're not watching this right now, and I'm not being disrespectful. I'm sure there's somebody watching this right now. Most people aren't. They don't have time. They have busy lives. They're not watching. They're not going into the public gallery of Belfast High Court. They rely on the media to tell them what's going on in Northern Ireland, and we can't do that right now.
Point, and I'm not, going on and on about the point, but they expect the media to tell the truth.
Yes.
And therefore,
we can't tell the truth.
They believe it.
We're being shackled. We cannot tell the truth right now. And I think if you look at
But Sam, are you going to get a letter from a lawyer for telling the truth?
Yes.
You are.
I got one for my book.
No. But I'm talking about after you've published something which is the truth, which you assume is the truth, and you've checked.
Yes.
Are you going to get a letter from a lawyer to say that was factually wrong if it was the truth?
Yes. How? I mean, most of the claims that come against us, and I should add that when I say that there are probably 30 or 40 cases that I have seen in my time as a journalist, many of those fade away. As I've said, Arlene Foster, Michelle O'Neill, they just go. They run down the clock and they go, and that's it. So it's not that these are all being successful, but they chill us for that year. There is a concern there, and I think that it is a misunderstanding. Something that Paul Tweed said earlier about truth being. I mean, I'm paraphrasing him here, but he basically said that if it's true, what do you have to worry about? I think you've said something similar, and that is something which fundamentally understands the libel law. The libel law is not about whether something is true; it's about whether I can prove it's true. If you think about some of the greatest journalistic investigations in history, Watergate, the News of the World phone hacking scandal, MP's expenses, There were lots of things in there that we now know were true, and they didn't know at the time that they were true. They took risks, and actually, in each of those stories, they got things wrong. They said things that actually weren't true, but they did it honestly. They were trying to get to the truth. Society already recognises in defamation law that there is privilege. For instance, in what we're saying here today, you can put something to me that is entirely untruthful, and you rightly, and I rightly, if I respond to it, am protected from being sued for that. So society accepts that there is some benefit to society, the law accepts that there's some benefit to society in encouraging the sort of investigation that might uncover something and report something that turns out to be wrong. But it's better that than that the whole thing gets suppressed. That is good, that is right, and that is what we need to do more of here.
And one final question, if I may. I think it's clause 5 regarding the whole website thing, Sam. What's your thoughts on that clause? Forget about the bill and just that clause. Does that protect, the individual, or is that protecting the website? What's
sorry that I don't have the bill in front of me. I should have printed out. Can you just remind me exactly which one that is?
Of websites, basically. Defamation, obviously, if an individual posts something about another individual, you have to prove, the website operator, I understand, has to prove that it was you said it.
Yes, okay. Yes, so, I mean, that probably is one of the areas of this, along with, for instance, the protection for academics and peer-reviewed journals, etc., that doesn't have so much of a direct impact on me. I think it does, in some cases, have an impact on newspaper websites where you'll have a comment section beneath an article. So I write an article about what's going on in Stormont, and somebody comes beneath it and says, this is absolute tosh. That protects that discourse, that readers can have, but it's more significant, I think, for people who are outside my line of work.
Should this bill not be heading more, and this is the final point, should this bill not be heading more in that direction, not taking away from written journalism, should I say, or paper journalism, in the direction of website, because that's where it's not saying it's heading away from paper, but that's where it's going. So it's weak on that front.
Well, I think that David made a very good point about the single publication rule, and something that probably seems to you incredibly technical and boring, and sure, this doesn't really matter at all. It's absolutely fundamental. So you've got a situation where, as he said, if I published something through the newsletter in 2009, I've lost my notebook, perhaps. The person maybe that told me it as a source is dead. All sorts of things have happened. Things have moved on. The libel law, up until now, historically, has said that after a year, if you are wronged by that, you can't sue over that. You've had a year. You've had more than enough time. After that, the statute of limitations kicks in. And in Northern Ireland, it just doesn't. So you can sue and sue and sue. I mean, that is, you can imagine what that's like.
Just for clarity, or maybe David knows that, or maybe Jim, maybe you might come in. Why is that?
So it's to do with the 2013 Act, as I understand it, not being extended to Northern Ireland. It was one of the sort of technical things in that bill. It wasn't probably discussed as much as some of the other elements of it. It wasn't as controversial.
There is a basic 1 year of imitation.
Yeah.
But I think the view is taken that when social media repeats something, that's a fresh publication.
Yeah.
It's actually more than that, because it's not even social media. If it's on the website. Yeah.
Sorry, go ahead, David.
Sorry.
It's not repeating. It's the availability.
Yeah.
So I think one of the people on the committee put it very well. It is the accessing of the article online, which is deemed a new publication. So there's a 1990s case in the early days of the internet, which deemed each accessing of the online article to be a fresh publication, triggering a new limitation period. That may have seemed a sensible decision in 1997 or whenever the case was, when people didn't really understand the impact of the internet. But it stuck until the 2013 Act, which removed it. So online publication is treated the same way now as a broadcast or a newspaper publication in England, Wales, and in Scotland once enacted.
Can I just make one more comment, sorry, to Mr. Buchanan, which I omitted to say there. So basically, there are three principal defences for a defamation action. The first is that it's true, and that's what you're referring to, but it's not the only one. The second is that it's privileged, so it's said in a court case where obviously I don't know if it's true. I mean, I'm just reporting what's being said, or it's said in this place. And again, it would be quite wrong if I was to think that I couldn't report what was said here because I have to prove that what you said was true. You're a public representative. It's important that the public know what you're saying. saying, and so therefore that can be reported and no action can be taken about that as long as it's fair and accurate. And then the final one is about fair comment. And again, that's not about truth. So you may think as a DUP MLA that Sinn Féin are an appalling political party. Sinn Féin might think that the DUP are an appalling political party. That's not empirically true or false, I think. And I know that there'll be people who disagree about that. But it is your opinion. It's your opinion based on your experience, on facts that you think are important, things that other people think aren't important, etc., etc. And it's very important that that is protected. And so in the Gregory Campbell situation, what I was clearly doing was saying, here is something that's not necessarily a fact. This is my analysis as a political journalist, as somebody who lives in Northern Ireland. But you can't prove it's true. And I wasn't seeking to prove that it was true, that as he thought I said he was a terrorist, for instance. So it's not. I think it's too simplistic to simply think if you can prove that, if it's true, it's okay, and if it's not true, it's not okay. And secondly, it's about proving that it's true. And so if a civil service whistleblower comes to me, it may well be that they've given me documents, they've given me things that I am satisfied show that what they're saying is accurate, but they cannot ever allow me to use those in a court of law because they would lose their job.
Okay. Just a final.
Sorry.
Thanks, Keith. Final question for me, and thank you very much indeed, and thanks very much indeed for everybody. I know this has gone quite a long time, but I think it's been very important. And just for information, Sir Robert and his team have agreed to go for another day, so I'm not asking you to stay here until late, so I can see Alicia's quite happy about that one. But the question we have here is the legislation we have in the rest of the United Kingdom, or in England and Wales, okay, and we have diverged from it. So the issue is the significant divergence. We're actually looking to get a piece of legislation to bring us into line with the rest of it, but it could potentially diverge again. Mm-hmm. Stand fast the fact that we'll be looking at Supreme Court sort of precedents and the rest of it. Should we not be looking to make sure that we're part of sort of the rest of the UK legislation, and that is part of it, rather than having a separate piece of Northern Ireland legislation? I'm just asking that question just because the more I've heard today, the more I understand the sort of the complexities of where we are. But I would just like both of your opinions. David, could you come in first, and then Sam for that one?
I think it's for everyone, for claimants, plaintiffs and defendants, it's helpful to have a unified body of law. And it's very difficult for me as a pre-publication lawyer advising a Panorama or a Spotlight or a Nolan programme to always have in mind the outlier risks that exist in Northern Ireland. And I think I've made the point quite extensively that moving forwards, I do see it's very difficult how an informed body of law can evolve, given that defamation law really evolves through case law decided by judges, but the role of the jury in Northern Ireland, and it's a small jurisdiction, means there will be very little case law on what honest opinion is. And you're detaching yourself from the honest opinion defence in England. There'll be very little case law as to what the threshold is for bringing a claim, whether it's serious harm or the current slightly lower test in Northern Ireland. So I think there is I don't see that can be a healthy situation for anyone, because it just creates huge uncertainties where, as I've said, the body of case law which will be applicable is increasingly disappearing in the rearview mirror.
Okay, thanks, David.
I think that there is always a temptation for this place to want to tinker with what comes out of Westminster, because that's the national parliament. We saw it in RHI, where a very complex area of law was, as it seemed, relatively, it was changed in a relatively minor way, as was thought at the time. We've seen it with this in a second very complex area of law, which even to me as a working journalist who has studied media law, has lots of experience of cases, etc., find incredibly difficult to understand how case law interacts with statute and all of the various issues here. I think that the Assembly should be really cautious about altering this. There are bits of this that probably I would want to change, that Paul Tweed would want to change, that you would want to change. I think that in a jurisdiction where an organisation like the BBC operates on a national basis, where lots of newspapers are circulated nationally, where lots of what we consume is national in character, once we start significantly diverging from the rest of the UK, and this is not the end point, this is the start point basically, or the start point was 2013. We've already diverged significantly. It's going to continue. It's going to get worse. And just because there's not, there has not been the situation where, for instance, the Times or the Daily Telegraph or the Guardian have stopped circulating their print edition in Northern Ireland, don't assume that that won't ever happen. Print circulations are falling. Newspapers are increasingly taking tough commercial decisions. If there is a high-profile case that costs him a lot of money, that is a very real risk, I think, in this jurisdiction.
Okay, thank you very much indeed. David, Sam, thank you both very much indeed, and thank you very much indeed for your time.
Thank you.
And I think that has been a particularly, I think the entire afternoon has been a particularly valuable session. Gentlemen, ladies and gentlemen, we're moving on very quickly in correspondence. I promise to counter through it with at a rate of knots. That's nautical expression for speed, Militia. So we get to it. Sort of.
I'm familiar with it.
Yeah. Next item is correspondence. Correspondent index. There are 9 items to receive correspondence. I think the non-domestic rates valuation bill, I think we will take that
on Monday.
Well, Monday, we'll do that discussion there on Monday. We'll go through as well.
So members content to note for now?
Yes, please. Great.
Yep.
Next item, notice of amendment. Members asked to note at page 397, notice of the Department's NIPSO amendment to the consideration stage of the Financial Reporting Departments and Public Bodies Bill. The committee has previously endorsed this amendment. The consideration stage of the bill is on the 7th of December. Are we content to note? Noted. COVID support overpayments. Members asked to note at page 398 a response from the Department for the Economy to committee queries relating to COVID overpayment, fraud and error for the Department for the Economy schemes. It would appear that good faith write-offs may be applied to the COVID Small Business Support Scheme, but it hasn't happened as yet. There are 10 suspected frauds associated with the scheme, which have been referred to the PSNI. Are we content to note?
Yep.
Note. Financial transaction capital. Members asked to note on page 407 a response from the Department of Finance to committee queries, again declining to provide information on unique circumstances funding and providing a breakdown of FTC bids and allocations. The level of underspend is shown on page 410. The committee has already written to the Department re unique circumstances and seeking a further breakdown in the uses of the FTC. It's not acceptable. I think we need some answers to that, and we'll write to them again and tell them to get on with it. If we're agreed, agreed. Barnett consequentials for health. Members are asked to note at page 412 information on health Barnett consequentials. That was an assembly question from you, Jim. Are the committee content to note? Good. Note. Agreed. PTSD, Northern Ireland Civil Service Injury Benefit Scheme. Members asked to note at page 419 a further response from the Department of Finance in relation to the NICS Injury Benefit Scheme, indicating that medical advice will be sought, thank goodness, in respect of the treatment of PTSD claimants. I think we're moving in the right direction. I don't think we've got there yet, but I think at this stage we're content to note. Agreed?
Great.
Next item, Commission for Victims and Survivors. Members are asked to note on page 422 an invitation to an event on the 7th of December entitled Better Together, reviewing the needs of victims and survivors of the Troubles conflict, launch of research funding under Peace 4. Are we content to note? Great. Members' Development Personal Security. Members asked to note page 423 an invitation PSNI training on personal security on the 15th of December. This clashes with the Finance Committee meeting, but other training will be provided in 2022. Are we content to note? Great. Office for Statistics Regulation. Members are asked to note at page 425 an Office for Statistics Regulation report on Phase 2 of the Northern Ireland Census. A 97% completion rate is recorded. The report indicated that NISRA has made little information widely available on the steps it has taken to investigate or otherwise meet user needs for data affected by COVID-19. This is a significant gap in the assurances offered by NISRA on its plans to address impacts on data. The report also indicates that further steps need to be taken by NISRA to communicate plans and provide more detailed information when available to users of UK population estimates, UK census data and Northern Ireland outputs. I think we should be writing to NISRA just for an explanation. And obviously, you know, NISRA have been pretty good in providing data in the past, so just like them to ask them whether they've responded to this OSR findings and ask them if they have any observations on it. We content?
Yep.
Thank you. Agreed. Composite information request is at 448. Are we happy to note? Agreed. Excellent. Moving forward, the forward work programme. Draft forward work programme is on page 464. In respect of the non-domestic rates valuation coronavirus bill, the committee has agreed to undertake an additional meeting on the 6th of December in order to hear from stakeholders. We're set to hear from local government as well as hospitality and retail sectors. The Institute of Revenues, Rating and Valuation have not yet responded. That was the one that Ian Snowden said that they consulted, wasn't it?
I think they gave evidence to the Westminster Committee, but he did mention that organisation to yourself and me.
But they were the only ones they'd consulted with, wasn't it?
They were the only ones who replied to the Westminster organisation. I don't know, to the Westminster Committee, I do not know that the department actually consulted with them.
Okay. The department's information also suggests that the sports sector may also be affected by the bill. Since there's not a lot of time for evidence, but does the committee also want to try and secure oral and written evidence from this sector on the bill? I think we would do. I think that would be important. Sports sector. That's agreed. A note of apology in advance, and thank you, Keith, for volunteering to chair the committee on Monday. Unfortunately, I'm a member of the Christian Aid Ireland Board, and we have a significant meeting on Monday that I have to attend, obviously with lots of issues to do with Africa and various things that are going on at the moment. So please accept my apologies for that. But Keith has volunteered to...
What time's our meeting on Monday?
It's 1400, I think.
2:15.
14:15. Next, in respect to the committee stage of the Defamation Bill, UTV and the Law Society have declined to give oral evidence. This leaves a gap in our agenda for next week. Peter has lately received quite a lot of written information on RHI disciplinary matters. It is therefore proposed that the committee considers this in closed session next week. I think that would be quite an appropriate use of our time. Thank you. That's agreed. Does the committee also want to invite the National Union of Journalists to provide oral evidence on the Defamation Bill on the 8th of December, if they are available? I think that would be... Yep, agreed. Are the members content with the forward work programme as amended?
When are we now going to hear from the Fiscal Council?
Good question. I think it'll be difficult before Christmas, Chairperson, but...
Can't fit in next week, no?
I don't think so.
Okay.
Look, I think that when the Minister comes on the 15th of December, he'll talk about the budget when he does, and then we would probably expect to hear from the Fiscal Council a month later with their report, so that might be the time. I know it's a long time.
I will indicate to talk to Sir Robert tomorrow and sort of pass on our apologies. We had a meeting with him earlier on, which was quite useful. But he was indicating they were mostly going to talk about this report, not on the sort of the budget process as it was. It is our understanding that the budget is going through the process at the moment, so it should be going out for consultation. Yeah, I know. I am full of expectation that it will go out for consultation fairly soon. Okay. Any other business? Thank you very much indeed, everybody, and thank you very much indeed for today's session. I found that particularly valuable. Next session will be in here on Monday at 14:15. Thank you very much indeed. Hereby adjourned.
Thank you. Thanks a lot.
Bye.